Paul, can you hear me?
Yes, I can.
Okay. Good, bad?
I can hear you just fine.
Okay. New mic system. We're trying it out.
Oh, that's good.
Yeah.
Are those all mics around the side tables?
Yeah, they're all wireless mics.
We have joined the computer age.
The other mic always remind me of the Larry King mic. That's yeah, that's when I saw that. That's what it always remind me of.
What's the weather been like there?
Cold. It's only about 40.
In a quarter mile, turn left onto Martin A. Coughlin Bypass Road.
Jason, you're not muted.
I'm not muted.
Nope.
I can mute, but then if anybody wants to hear from me, they won't be able to because I'm driving.
No, that's fine. I mean, you can unmute.
You'll just hear my directions to Logan Airport is what you'll hear.
Oh, that's exciting. We'll travel with
Turn
you.
left onto Martin A. Coughlin Bypass Road.
So, well, actually, I'm not going to mute right now because if I do that, I
That's
will
fine.
be being dangerous. So once I get stopped, I can mute and unmute
In 1,000 feet,
appropriately.
turn
I
left onto
apologize.
Dennis Road.
It's the only way I can attend.
No problem.
Ready to go.
I tried to get
Take the next left toward
set
Neptune
by
Road,
6
then
o'clock,
slide
but I
right
got
onto
stuck in
Neptune Road.
Boston area traffic.
Yeah, mute them.
Oh, that's a good idea. You can mute and unmute them.
Oh yeah, you guys can mute me, and if you need to ask me something, then
Slide
unmute
right
me.
onto Neptune Road.
Everyone, Steve, you gotta put your microphone on. Just push
Push the button right there. It turns green.
Let's call the meeting to order, please. See, Paul Bowden is joining us via Zoom. Danielle Black is excused. Joe Chenard said he would be here. Get going anyway. So let's see. I'll take a motion to skip over item 2, consideration of the meeting minutes from April 2nd, April 10th, excuse me, and move on to for two major subdivisions related.
So moved.
Is there a second?
I'll second it.
Steve, all in favor?
Aye.
Two major subdivisions. Ethan Conley, excuse me, and Kyle McManus. Come on up.
How you doing? Good evening again. Keith Covered with Bold Engineering.
Evening, gentlemen. Derek Blake with Orin Reno. My colleague Bob Perry has been filling in for me for the last couple of meetings, but I'm back. Okay. Glad to be here.
Yeah, sorry I missed the last meeting. Austin Turner from our office filled in for me, but obviously you guys are familiar with my face. I've been here every other time, so.
Do you have any updates for us since the last meeting?
Sure. So actually Ray Kober sent a common response letter, I believe it was yesterday, last evening around 5:30. With very few comments left, and we actually discussed it before he sent that to me. And his comments are based on the last plan submission set that we made on 4A. So there's a couple minor things. We went through it and don't see an issue with any of them. So we'll be able to address those.
And on my side of things, Jason, Dennis and I spoke over the last couple of weeks about easements and HOA and that type of thing. I think all those things are squared away. The bottom line for those are that we are asking for conditional approval tonight, and then Jason and I will flesh out the details. Some of the documents have to be prepared after the plans are approved, so they're on record, and then we can reference the recorded plans in the HOA declaration, that kind of thing. But in general, the idea is that there will be one HOA. It'll address issues with respect to the roads, and I know there's some discussion about drainage, and the HOA is going to have control over the drainage and responsibilities for the drainage so that the town has one go-to entity or organization that's responsible for all of it. There's a couple of cross easements and things that Jason and I talked with. Again, those look fine, I think. There is a no disturbance easement for areas around the wetlands. You guys may remember we did a similar document for South Peak for the wetlands area over there. The document here would be essentially the same. The only exception is the clients want the ability to cut trees in the wetlands if necessary for view reasons, but the the stump and all the roots and all that will remain in. I talked with our engineer about that, and so long as the stumps remain in, the wetlands will function as, fine as well. So I think all of those issues are addressed. There are a series of cross easements within the development, shared drives and that kind of thing. I'm not sure if Jason needs to review that. It's kind of up to you guys. It really is going to be for the folks in the development, and the developer needs to get it right. So when he sells the lots, they're all happy. But our bottom line is, I think we're ready on that front for conditional approval. I think generally, provided there may be a few issues tonight, but the goal is get it conditionally approved. Let Jason and I work through those issues just as we did in South Beach. So that's the idea.
Okay, let the record show that Joe Shenard is seated tonight. Any members of the board have any? Oh, Joey, put your microphone on, just push the button. There you go. Any members of the board have any questions? Paul,
Am I muted or unmuted?
you're unmuted.
Yeah, I can't tell. I've got my wife's computer. I'm sorry. I'd like to know if we have written documentation from Jason and Ray pertaining to the what are they? Ray had 2 reviews that he was doing. I guess my point is, has Ray reviewed this? And do we have anything in writing from him stating that he's all set with all his comments?
Okay, I think Karina's gonna weigh in on that.
Yeah, I can speak to that. I spoke to Ray about an hour ago, and there is a technical memo number 3 that they had just referenced, which was sent yesterday. So they are correct. There are about a dozen or so outstanding items, but I do believe that most of those can be sorted out with if the board chooses to do a conditional approval this evening. I do believe that most of those can be sorted out through the, technical, just as with similar applications have you done in the past, just making sure that it's passed through all the technical review stuff. But yes, Ray has reviewed it, and it is in writing, technical memorandum number 3.
I would like to see technical memorandum number 3 prior to giving an approval for sure. I mean, I don't know what Ray's had on it, but I haven't seen it. Certainly would like to review it for myself.
I don't know if the planning board was forwarded it, but I can make that available. I can send it out
Yeah,
right now.
I haven't seen it.
Okay.
Yeah, I mean, obviously it was sent to me, but Carol, I know, was on vacation, but she was copied on it. So
Mhm.
it was, I'm sure Ray did send it to the.
Yeah, I've seen it. I have it right in front of me. I could send it out right now, Paul, if you'd like to see it.
I
But
can
it doesn't
figure out
really
how to
help.
get
It
to
doesn't
it.
really help everyone else on the board. But I will do so.
Yeah, I certainly would like to see it. If I can figure out how to do it.
Well, if you could email it to, maybe you could email it to Ron and he can print them off for us.
I have a copy here.
Oh, there we go.
I
Okay,
mean, I got like chicken scratch on it, but definitely, yeah, you can definitely make a copy of it right here.
okay.
Go on.
And also, do we have anything from Jason in writing as well pertaining to the comments that he made as far as the approval?
Yeah, why don't you want to make copies, please?
Yeah.
That'll.
Oh,
Okay, yeah, give it to Ron and we'll.
So with respect to Jason, I would suggest that he chime in. I know he needs to be unmuted, I think, in order to chime in.
Yeah.
Yeah. he needs-
Jason?
Yeah.
He's driving, but he said, let him know, so.
I mean, I guess one of the things that we were talking to Ray about as well was bonding. And Ray was going to give an estimate of bonding. Has that been acquired yet?
So if I can speak to that on that note, I've talked with Ray again about that yesterday. So the idea was we're waiting for conditional approval so that we then can provide the bond estimate, and then Ray's going to review it. We did send to him this afternoon the items that we're gonna plan on putting into the bond estimate, but yes, that would be a condition that would send that for Ray's approval.
feel like I'm going in blind here because we don't have a lot of stuff in front of us to look at here. Everything's, someone's gonna provide something, and we don't have it tonight.
Well, this is Derek. I can express my frustration about that. I mean, I don't know what meeting we're on, 7, 6, 8.
Yeah, a
This-
lot.
And the issue we're having, frankly, is that Ray seems overwhelmed and is not able to turn over stuff in time. So I don't want to be delayed again tonight because the town consulting engineer can't keep up and can't provide comments until 5:30 the day before the hearing. That is not our responsibility. As you've heard represented, our engineer has talked with Ray. They worked through this, and you can put conditions on that. The final technical issues that Ray raised need to be approved by him as a condition subsequent. We have no issue with that, but we don't want to be held up again. Frankly, every time we're held up, all that happens is Ray then sends another technical memo and talking about things that have been pending for 6 months, and we hear about them for the first time. We just don't want to be in that cycle again and again and again. It just never stops. So we need it to stop at some point, and you guys just have to pull the trigger and make a decision. Otherwise, we'll be here forever waiting for Ray to just keep providing comments ad infinitum. I've never experienced this with another town, by the way, where the consulting engineer just seems to be so overwhelmed with projects that he can't keep up, and things that are typically approved in a month or two in other towns, 1 or 2 meetings are taking 6 and 7 and 8 meetings here. It's just, I'm not.
I mean, some of those meetings, they were conceptual meetings. They weren't actually,
I
hearing on the merit.
completely understand, but,
Mhm.
I'm not faulting the town. I think the town's got a lot on its plate. But what I am saying is the applicant shouldn't be penalized because the towns doesn't have the capability of keeping.
and I would point out there were a lot of rebuttal issues we had to work through as well.
I understand, and I can point out here, I've seen it in this instance, and I made a comment about it to Carol, including an email, that we're going off on tangents in many cases where Ray is doing things that were not requested by the board, nor relevant in any way, essentially completely reconceptualizing the design of this project, and then submitting that and saying, hey, why don't you think about this? And again, I've never had in any other town in 25 years, an engineer, instead of doing a technical review, they say, well, if I were doing it, let me do my review and let me say, oh, I'll completely redesign things and put in different roads and reshape lots. And like, whoa, whoa, whoa. I mean, there's a reason this is taking too long. And it's because we're not we, but the professional
Mr. Chair?
staff is not staying
Jim?
the point.
Yeah, go ahead, Paul.
Yeah, I'm sorry, I can't remember the gentleman who was talking, but
Derek
Uh,
Lick.
Yeah,
Yeah,
sorry, it's
yeah.
Derek Lick.
there. Hi, Derek. So the questions I have, Jim, is Ray on tonight?
Ray's not on.
Can I ask why not?
Karina, can you answer that question? Paul is,
Yeah, he has had some medical appointments, which he's not available to attend.
that's fine, okay.
Can I just go back to the bond estimate again? We've discussed this before during hearings that again, just we asked for that as conditional approval, and then we talked about, again, we've talked this way numerous times. He's agreed that again, we would submit it for his review upon conditional approval, and that would be a condition that he has to, that he reviews it and agrees with the bond estimate.
Jim, I would
Yeah,
like to
exactly.
offer that I understand what these gentlemen are saying. And I'm certainly sympathetic to it, but to make a wrong decision simply to make any decision without having all the appropriate information could be a wrong decision. No matter what the timing is, we want to make the right decision.
Well,
And
The bond is a perfect.
there
sorry,
have
the
been,
bond-
All right.
excuse me, but there have been a lot of abutters concerns. The planning board has asked a lot of questions. There's been between legal counsel as well. So I mean, I think it's the best interest of the town that we do get the right information. I do sympathize with you for sure about how long it's taken to get to this point. And I do think that there are some responsibilities that weren't paid attention to that probably should have been. But that's not a reason to make a wrong decision. So, or to hurry a decision. So I think we need to make sure that we've got the right information before we make a decision.
Well, on the bond, for example, it's a perfect example of a condition subsequent as opposed to now. In order to get the bonding quote and understand the details of it, we need approved plans. We can't get information on a bond without conditionally approved plans. So,
Well, the bond typically, from what I understand from Ray,
Let
Paul,
him
let him
finish,
finish.
please. Let him finish.
I mean,
I'm sorry.
It's just a reality of, it. I mean, there's a lot of cart before the horse and we need conditional plans approved before we can do many of the things that the board is asking us to do, which is perfectly fine. We do this in other towns all the time. It's just a matter of sequence more than anything else.
Okay. Paul,
Yeah, I mean, I thought Ray had
hold
talked,
on. Oh, I think Jason has his hand up.
yeah, I'll yield to Jason.
I do. Can you guys hear me?
Yes, we can.
And it's for one very important reason, and that is because this application was deemed complete, there is now a deadline, which is May 12th, which is a Saturday, which I would then move to Wednesday, May 8th. That is the deadline per statute for a decision to be made, one way or the other. That doesn't mean you have to approve it, obviously, but you have to approve it, deny it, or deny it without prejudice on or before May 12th, which again, I think kicks it to May 8th because you're probably not having a meeting on a Saturday. So I just wanted everybody to have that information in the back of their minds as we move forward with the rest of the discussion.
Thank you. Sorry, Paul, go ahead.
No, I mean, so Jason says May 8th. So today's the 24th, so that still gives us
2 weeks.
week and a half to be able to, I mean, I understand, we're pushing the timeline here and we don't have the information.
Paul, have you received the email with these with Ray's technical review number 3?
You know, OJ, I have to apologize because I'm on my wife's computer in Georgia and I don't know how to run to get it at the in the same time frame here, but if you want to speak to him, I will certainly listen.
Yeah, I mean, I think it will add to the conversation because again, you were talking about, you know, all of the abutter issues, and I think that's what we have to make a decision on is the application as we understand it. To stop this right now and not make a decision based on this last letter, I think it's helpful to know what's in the say the technical review, just to know what's in it. So number one is to submit state and federal permits for the project, which I believe it's inappropriate really to do that before you get approval, because if we change something tonight, every permit you've applied for becomes
Correct.
null and void. All right, so let's move on. We understand the design intent is all that is remain in all the retaining walls shall be less than 4 feet in height. Please verify that all retaining walls are less than 4 feet as measured from the bottom of the base course to the top of the wall. Please add a maximum of 3-foot dimension to the exposed wall height in the fieldstone wall detail sheet 904. In addition, please verify that the pipe opening invert elevation for the 24-inch diameter culvert that discharges to lot 24 is correct relative to the proposed retaining wall elevations. Again, that to me would seem like a technical thing that the planning board isn't going to decide if.
Correct. And I spoke with that,
24.
Ray. It's literally an invert change in the plans and adding a 3-foot dimension to the detail. That's all it is.
Number 3, all easements required for the project shall be obtained prior to the issuance of the LUP. Please delete note 3, residential note sheet C102. Provide all easement documents for review by the town attorney. Please provide a schedule of required easements listing type, grantor, grantee, respective lot numbers, etc. And I think that we already talked about that being a condition of approval. Jason, do you see any issue with making all of those easements a condition of approval rather than getting them all written out? You know, I mean, if this is a project that gets turned down, do we need to see what easements we're turning down with it?
No, I think it makes the most sense to make that a condition because of what you said, A, to not waste everybody's time to draft easements for a project that's going to be not approved, but also once you approve it, if there are other conditions that get on it or any final tweaks or changes in the final approval, then you want to know all that before you make the final revisions to easement language. So it makes the most sense to do it as a condition. That way you know exactly what the project is and tailor the easement exactly to it.
Thank you. Number 4, consideration should be
Well-
given to securing a permanent maintenance easement for the retaining wall along the property line with lot 50 to ensure the proper maintenance, repair, and future replacement of the wall if required. I refer to sheet C 402.
Spoke with Ray about that in error. We showed a construction easement for that wall, which is like 2 feet high. It's not needed. So therefore, since we don't need the construction easement, we don't need a maintenance easement. So Ray left that comment on here for me to respond to that way. It's not needed.
Did Ray agree it's not needed?
Correct. He did.
Okay,
He was just thinking that we needed a maintenance easement because we were asking for the construction easement. Once I explained to him that we didn't need that, he was fine.
number 5, the outlet to the 18-inch cross culvert appears to require a permanent drainage easement. Refer to sheet C 402. I mean, if does that require an easement? And if it does, is that something that just we can make as a condition?
Yeah, you can make it a condition if necessary, but I don't think it is. This is an existing culvert already. So it's in the same spot, whatever's there, it's gonna be the same. It's just a replacement or.
It's a replacement.
Yeah.
Yep.
So I guess it's a question whether make it a condition or is it not needed?
So they can, either way, they can work it out administratively.
I suppose what I would do is, this could be one that Jason and I can talk through when we get to talk about all the other easements, put this in the list, and Jason thinks it's needed. We'll do it. If it's not needed, we'll. Is that okay?
Mhm.
Does that work with you, Jason?
That works with me. And on some of those ones that have a little bit of a technical component, I do consult briefly with Ray. And so if he thinks technically it's needed, then I decide if legally it's needed. And then if that's the case, I would work with Derek on it.
Thank you, Jason.
You're welcome.
All right, number 6 is show an easement on lot 7 to accommodate the installation and maintenance of the level spreader on lot 6.
Same thing, another easement that will be.
Add that to the
Yep.
list.
Okay,
That one is a new one that I hadn't heard of until I saw this yesterday, but it's easily done.
provide a statement regarding ownership and operation and maintenance of responsibilities of roadway utilities, water, sewer, drainage, et cetera, and retaining walls. I assume that'll be a part of the HOA agreement?
It will be, the HOA will be responsible, to the extent he wants a statement on the plan saying the HOA will be responsible. I'm sure that's.
Yeah.
in that.
Okay. Please add the following note to general notes on sheet C 102. The owner shall provide a construction sequencing plan to the town of Lincoln prior to the issuing of a land use permit.
Yes, so that's something we can't do now because again, we don't know what part of this project's gonna start, right? So depending on where our client is going to start, then we can write just a sequencing for that. So that was something that Ray wanted added to the plans, which we can do.
So we can make that just the statement that the owner shall provide it needs to be on the plans, that the actual sequencing plan doesn't need to be.
Correct. Yes, you just want to make sure that we added the note, so
Okay.
therefore then the client's
So that-
responsible to provide that
the notes
sequencing.
get-
Yep,
Is getting added.
yes, that, correct.
Okay. Next one is prepare required documentation and verify that plans meet all requirements as specified in sections 502B, 504, 508 of the town subdivision regulations. Submit documentation and revised plans as required.
I think these are just note references on the plan.
Yes,
Am I right?
exactly. So that's the third, fourth, and fifth sheet that is highlighted. That's the what Ray's pointing to, that basically just adding those notes to the plan. It'll fall on what we need to do. Like it talks about obviously doing the plats and making sure we pay the fee for the recording and all of that. So we don't have any issue with any of these, your typical, requirements. So
Okay, so I guess, could that be a condition of the approval then?
yes.
That
Yep.
those will be, that
Yes.
documentation?
Yes,
All right. Show the location of the existing drainage in Valley View Lane. Sheets C 401 and C 501.
that's just, there's 2 existing catch basins in Valley View Lane. They're just out of the viewport. So we want to make sure that we're gonna have to tweak the viewport to show those. They're
Okay,
down gradient of the site. He wants to see them on the plans.
okay. So that's something that you will work out with Ray to add to the plan.
Correct.
Consideration should be given to providing a vault for the air release valve for the water main to ensure access for maintenance, repair, and replacement of the valve. Provide a vault detail as required.
Yes, so we can add that to make it easier to maintain in case there's an issue with the air release valve.
All right, in sheet 901, trench repairs, specify 12-inch gravel aggregate base course below the crushed gravel base course.
Yeah, it's a detail revision that we'll make.
Sheet 902, rain garden, depth of the soil media specified 15 inches conflicts with the HydroCAD model of 18 inches.
Yep, we'll just be making that change from 15 inches to 18 inches. for the
Okay,
Media.
and add exhibits to the inspection and maintenance plan showing the locations of the stormwater management practices. Submit the inspection and maintenance plan as a separate document. We already talked about that being a condition of approval, the maintenance plan.
Yes,
And I sent Ray, I have a lengthy set of comments or things that I would like to add to that maintenance plan.
yeah, so we added, your comments before was you wanted each specific BMP added to actually the log. We have added that
Okay,
to the plans. So all he's talking about here is he just wanted some exhibits to go with that, so it makes it very clear for the HOA. And it's basically we're taking like the grading and drainage plan and dumbing them down and calling out, this is rain garden A, this is rain garden B. So we're, literally just doing 11 by 17 exhibits that attach to the maintenance plan, make it dummy proof for them to be able to follow the maintenance requirements. That's all he's referring to, which we can do.
all right, and the last one is to provide an estimate for the performance bond. You said you submitted the items.
The items, and we're waiting for hopefully conditional approval, so then we can complete that, because obviously, again, you can't put the cart before the horse.
Paul, did you get all that? Do you have any questions?
Yeah, can you hear me now?
We can hear.
Okay, yeah, I was gonna ask what those items were for bonding. That you guys were considering.
So it's a whole list of things. It's from all the utilities, so to install the electrical, the water, the sewer, the roadway, the curbing, all the earthwork associated with all that. It's, constructing the basins, seeding the basins, the landscaping for the evergreens around basin 1, the seeding for the for the basins, the plantings for the rain guns. It includes all that. Basically, it includes temporary seeding in case, for example, like construction stops, client runs out of money, then you obviously can stabilize everything. That will be in there.
So we'll,
So, yep.
pardon me for interrupting, but.
That's okay. Sorry. So I don't have the list
No, no,
memorized.
no. I'm interested to hear what it is, because I had some others that I was concerned about. I wanted to make sure that they were at least considered. One was the a bonding. The town owns Mansion Hill Drive, am I correct? OJ?
Yes,
So shouldn't part of the bonding be to make sure that during any part of this construction that the Mansion Hill Drive is protected against any issues that may arise during the construction that might degrade the road? That would be one question for
Say
bond.
so.
That
I
would
would
be
think
one question for bonding.
yeah, I would think that'd be for all 3 town roads that are connected to this development.
Right, and I didn't hear that. They were talking
No.
about the roads within development, but I didn't hear anything about the roads outside the development. That's why I was
It-
asking.
The draft we sent today to Ray did not include that.
Okay, so I would think it probably should. I would
Well,
think the town would want
assume-
that.
I assume you're gonna cut a smooth edge at the end of some of the town roads one of them you're actually gonna length, correct?
No, that was before. And
That was
that mentioned here before, remember, we were gonna lengthen. Now we're just doing the shared driveway and the driveway off
Right,
that.
because you eliminated a lot up there and did the shared driveway.
So kind of that, like, we were showing that we're gonna mill and overlay at the end where there's a couple of utilities running through. Actually, I didn't coordinate with our client before then. Actually, now you brought that up. We wanted just, there's nothing in the regs requirement. We were just gonna saw cut and patch those areas. But the question just comes back to bonding the roads. I mean, those roads have been, they're kind of rough shape now, right? All the way up to where we're planning to develop, and there's numerous saw cuts and things. How do that get determined if, the construction vehicles do any damage to a road that's already, it's not like it's a new road that's been done in 5 years. How do you
All you do,
determine that?
all you do is video it before you start. And then, through construction, I mean, if you're running trucks up there in the spring, or when it's soft shoulders, or when it, you know, it starts pushing the manholes, I mean, I don't know very many projects that don't affect the current road surfaces. If it's gonna, I don't know how long you're gonna intend to take to do this project. I would just like the town to be protected, you know, and the people that live up there from any, you know, future deterrent road conditions.
This is Jason online here. I would just say
Yep.
that certainly the way that that could be considered to be done is that any of those town roadways, if they are damaged or disturbed, would be brought back to the condition they were at the time. Obviously, it would not be similar to what I think OJ has said a couple times about the water issues. It's not the applicant's job to fix current water issues, but the applicant shouldn't make it worse. Same with the road. The applicant doesn't fix the town road, but if they make it worse, then the bond would cover that.
Right.
So
And-
Jason,
and-
this is, I'm sorry, go ahead.
no, I'm sorry. Go ahead.
Jason, this is Derek. I
ahead.
just had a question about bonding. I've seen bonding done where you estimate what the cost of the work that's supposed to be done is, so that way the town can come in and do it if it isn't done.
Right.
I haven't been involved in a bonding situation where you essentially, you know, guarantee or ensure, you know, if you do damage to existing town roads. I mean, is that done, and can you estimate that somehow? I mean, how's a bonding company going to handle that? Have you been involved? Because I have not been involved in that kind of
It has
situation.
happened. It has
Yeah.
happened. Well, I mean, it has happened out back at Forest Ridge.
Yeah, we have,
They
we
were
have, a
actually
bond-
doing it.
Go ahead.
the town has a bond held on the, well, a couple of bonds, but the one at the Forest Ridge that's similar is from, I forget where the starting point is. I forget if it's the guard shack or at some point up into where it turns left to go to the Woodland Loop Road. The town had that bonded from basically damage from construction vehicles. And we've had that bonded for the duration of the project, which is years and years. Because they bailed out halfway through and they're still not done. But we're resolving that now and there's been no damage to the road.
Like Derek, I haven't experienced that before, so I'm not sure how to even estimate that, to be honest with you. I've done numerous bond estimates, I've never included that, so I'm not even sure what number to put to that.
Didn't we agree to not construct vehicles?
I mean, Ray should be able to help you with that.
Well, I would think our road agent would be able to help as well.
Yeah, I mean, you just want to protect the roads, that's all. I mean, it's common sense to,
Well, maybe that's a solution. I don't want to get out in front of my skis here, but if maybe the road agent could come forward and put together, say, that he would feel comfortable with X dollars sort of being set aside for that kind of thing, that may be a way to approach it. And I have been involved in projects where rather than bonds, there's some kind of like letter of credit or something like that. So that if a bonding company can't figure out how to deal with it. It sounds like, you know, there may be a mechanism to do this. I understand where the town's going. So provided there's some, you know, distinct clarity so that there's no confusion at the end where my client's building, you know, the end of the road brand new. That's what I'm trying to avoid.
Jim, the other one I had was, I mean, I'm thinking about all this from past history of the town and things that have come back to kind of haunt us a little bit. And the other one would be drainage issues, either surface drainage issues, and I don't know if you can include subsurface drainage issues in this, but, and I know it's all very ambiguous, but the town has had an issue in the past with drainage issues that were supposed to be taken care of and that weren't. So I think that in lieu of all the things we try to do to protect ourselves, I think it would be important for the town to also, as part of the bond, have something that could and should address that. If everything's installed as drawn and there's no problems, then there's no bond. I mean, that's the same thing with the road conditions. If they're careful when they run their trucks on the road, what time of year and how much they're hauling. I mean, common sense can go a long way to protecting the road, but also, you know, if everyone has installed what they say they're going to install, then there should be no issues. But we in the Town of Lincoln's Planning Board have seen issues when things have gotten installed, either as they said, and then turned out to be not designed right or otherwise. So I think it's important for the town to learn from those things and try and try and bond them.
So this one, Jason and I did talk about, we are perfectly fine, of course, bonding the fact that the project gets done and all the drainage is put in and done correctly and all that. With respect to any lingering issues, there is a legal mechanism already in place in common law that says if there's water that's coming down that was created by this project, it wasn't solved by the drainage. There's nuisance law that allows folks to come after the HOA for failing to maintain or correctly construct that. So that is a mechanism already existing. It is not a bond type item because, you know, it would just linger forever, and that doesn't exist. I think
guess
Jason
my-
is with that.
Oh, I'm sorry.
Okay.
I guess my response to that would be, I would rather have the town assume the responsibilities of making sure that there's not any issues, rather than having every single homeowner up there having to come after the HOA that is being built. I think the town should work to protect those homeowners, and the bonding mechanism certainly allows the town to have that ability.
Jason, would you like to weigh in on this, please?
Yeah, sure, I will. I agree 100% with the idea of protecting the town through bonding. And I think what I heard Derek say there is that they're fine with bonding for every aspect of this for which the developer would have responsibility through construction and design and getting the stormwater management stuff done. Once the project is complete and the homeowners have moved in and there's a homeowners association, there really is not a valid legal way to keep a bond on a developer for problems that are caused by a homeowner 10 years down the road because they just let everything go awry with whatever they're supposed to be responsible for. So every single aspect of the work that they would do or need to do or should do to get the job done right as far as construction and stormwater management can all be bonded. After that's done, that would fall to the documents that would also be a condition subsequent, which is all the HOA documents and easements and everything we've talked about to give people the right and the responsibility to deal with it. I mean, just the same way it is even like in a single home project. If the contractor's doing something and they make a problem, then it's the contractor's problem at that point. But if they are done and they've done their job fine, and then the homeowner years later creates a problem, that's on the homeowner. You can't sue the person that built the home for somebody doing something wrong with it years down the road. So that creates not a gap in protection for the town or the homeowners, but just a different mechanism by which that is protected. And yes, the reality is when it has to go through a different legal mechanism, it might be more time consuming, but that's the parameters within which we would have to work in this type of a scenario.
And I think
That's my opinion. You can't bond the developer indefinitely.
No, and I understand that. And actually, Jason, through the town system of having to sign affidavits for all the contractors having to sign affidavits, some of those things are probably taken care of. I would assume that the affidavit is a legal document, so to speak, that when someone puts in the stormwater or the sewer or water, whatever, those people sign those affidavits saying that they're done in accordance with town rules, regulations, and what the plan is, so that if something did fail, would the affidavit be able to be used to try and take care of things after that?
Potentially so. It depends on the timing. If it is done not in a workmanlike quality or poorly, or there's a construction defect of some variety, then in any construction defect case, you can go after the contractor that created the construction defect. So I'm just drawing an analogy to that situation. If the stormwater is defective and you don't know it right away, but you'd have to stick within the statute of limitations and the statute of repose. The statute of limitations is a certain period of time. The statute of repose is a longer period of time, but after that period, which I think is 8 years, then what we call the discovery rule is no longer in effect. So the statute of limitations, it can be extended by the discovery rule up to the statute of repose period. And I know that's technical legal stuff, but there's a time after which you would not be able to go after any contractor in any type of situation because the statute of limitations and repose is passed. But that, I mean, that's with any project, something
So if I
can you guys
If I
hear
could
me?
just go on, if I could just go on a little further, OJ brought up a comment earlier, during, about this application. He was talking about someone who, once this is developed, and someone goes in and starts cutting into a wetlands that they may or may not know is there and it changes water flows or goes a different way. Is all that handled through the association documents? Because that's one of the questions that OJ had that I thought was a good one. Is it going to be in the association documents that before they cut something, that they need to get permission from the association? So the association will look at it, and make sure that it's not in a wetlands or it's going to create a different way for the water to run.
That's an excellent question. And my answer to that would be, we've talked about the conditions for the HOA documents. I can't recall if that was specifically one of the types of conditions that would be in there. But from my perspective, it could be. So if the board said the condition subsequent is the HOA documents to cover this, including a prior approval thing, then we could work that out. I think. Obviously, I can't speak for the applicant. They obviously have the ability to object to that. But I think that is something that could specifically be added to those HOA documents and could be done as a condition.
All right, because
So
one
Jason-
of the conditions that I had on there was that Jason talked to Jason about legal consideration for language that protects wetland areas. And I don't know if that's
We did
legal
put wetland
consideration
protection in
for,
the deeds.
is it in the deeds or is it in the HOA documents?
Oh,
So I can,
Yeah.
I can answer that. So this is Derek Lick again. So what we will be doing is like what we did in South Peak, which we actually have a non-disturbance easement in the location of the wetlands areas. And that protects those areas, and it's just that it's a non-disturbance agreement that'll be in the deeds for each of the properties in which, they have a piece of that wetland. So if their property line, if the part of the wetlands is included in their lot, it will be subject to the non-disturbance easement, which means it restricts them as to what they can do, if that makes sense. On the other point, with respect to tree cutting in the association, I had not envisioned a scenario where the HOA had any oversight of tree cutting of the various lots. Part of that is because the way we've structured this is that there are certain easements that benefit the association, and those easements are basically the roadways and the drainage. The association does not have an easement over all the lots for all purposes to kind of keep an eye on them. It's really for the particular purposes. So the way I view this is with respect to drainage and roads, the HOA has the right to maintain and the obligation to maintain those improvements. With respect to wetlands, there's an easement that impairs each of the lots so that those are governed separately. You don't need the association stepping in or not. It's just as a matter of record at the registry for each of those lots, if that makes sense.
So Jim and OJ, how was one time we talked about legal language, and again, I think Jason, this was pertaining to with respect to the responsible parties for the common stormwater systems that were shared by either several lots or just, the whole development in general. How is that done? Is that done through how is that done?
I can answer that. So for any improvement for drainage improvements that serve the lots generally, that each of those is subject to an easement that's already shown on the plans to the benefit of the HOA, which means, let's say if there's a improvement on lot 1, the HOA gets an easement over lot 1 in that area for the ability to construct, maintain, and repair those improvements. There are some drainage improvements that are just between parcels. So, I'm making it up, but lot 4 has the benefit of a drainage easement over lot 5. Those have nothing to do with the HOA. That's between those two lots. Basically, it says lot 4 gets a benefit off of lot 5. That'll be handled in the deeds to those two lots. But that generic easement language will be in the deeds for each of those lots. That's how I structured it. Essentially, if it's a one-off between lots, it's in the deeds for those lots. If it benefits the site as a whole and we need the HOA to oversee and maintain it, such as the big improvements, catch basins, all that stuff, then those are specific easements to the HOA. Does that make sense?
Yes, it does. And when you're talking about maintenance, I'm assuming that that means paying for the maintenance as well. It's not just.
Yes,
yeah.
yes. Yeah,
So if something were to go wrong with any part of it, then whether it was a part of the common stormwater or a part of the one that was shared between lot 4 and 5, those would be done through easement language. I mean, through property language.
Yeah,
Is
yeah, exactly right. So the way it'll work is the association will be responsible for it. And we haven't figured out, frankly, I haven't even talked to the client about how that's going to be shared among the lots, whether all 25 lots are doing it or only the ones that are part of the HOA on the eastern side. But in any event, it'll be shared among the property owners in one way, shape, or form. And by the way, I hope that gives you some comfort because I understand the concern about future drainage issues. What we've done is we're putting that on the shoulders of the HOA. So that way, with respect to all the drainage improvements, the town has one place to go. They're responsible for it. And to the extent there's issues down, 10 years from now, you've got someone to go to and they have an affirmative obligation to maintain all those improvements. If whatever it is fills up with sand and starts not draining, they have an obligation to maintain it. And that's going to be in the documents that Jason's reviewing. So you guys can go to them at the end. That's the goal anyway.
Along those
Paul,
lines.
this is Jason.
Jason, go ahead.
Go ahead.
I just add very, very briefly that Paul, Derek and I have discussed this and we do agree conceptually. Obviously, he's got some language to work out for me to review, and my job in the review stage would make sure that the language actually carries out the concept, which is to add and create the appropriate protection. But conceptually, just for your consideration, we are in agreement of how to craft this. It's just up to me reviewing the specific language at the sort of condition subsequent type stage.
And one other comment I'll make, just also to give you folks some comfort. Jason and I have already done this with respect to South Peak. So another project still on the agenda tonight, Upper Crooked Mountain. There are a lot of cross easements on the lots. And so I've already prepared them, given to Jason a conceptual of all of those. And he's reviewed those. And basically, Jason, I'm going to take the same type of language there and put it over into this project for the certain lots that are in play. But you're going to already have seen the gist of it, just as you've seen it in South Peak. There's some variations, of course, but that's the general idea.
Yeah, that general idea, just for everybody, makes sense to me. And I follow the concept. The variations and things, obviously, I'm going to do my job and look at those and make sure that everything, I's are dotted, T's are crossed. But the concept and the language that already exists that Derek just referenced, legally, I guess I would say satisfies me. But we'll obviously make sure that the final project for this application, if it is a condition, if it's approved and the condition subsequent gets done.
Just read my notes. So we did have, they were going to provide us a stormwater inspection manual and reporting to the town when they inspect it. So, that's being taken care of. Paul?
Jim? Yeah, there was a question, I believe, that was raised at the planning board at one of the meetings about Mansion Hill. There was a gentleman there who said that the capacity of one of the basins to see if it will take more inflow. Has that been looked at? And do you know if that's been either approved or not approved by Ray or Nate or whoever that was going to look at that?
I speak, that's Keith Curran again from Bowler. I spoke with Ray about that yesterday and he said that he didn't have a chance yet, but he will get with Nate as soon as he gets back from vacation. I believe he said he's on this week.
Right, because I think you were going to direct some water into a catch basin on the Mansion Hill.
Well, it was really in Ray's court. We said that we looked at it and we said that we could do it by gravity. So we can get the outlet control structure from that basin one that's on lot 1 to the catch basin, this catch basin at the top of Mansion Hill. So then we said that we could do that by gravity. We were just looking for Ray basically say, yes, please do that. And then we can make that plan change.
So that would have to be a condition, Jimmy? Is that making sure that that's?
Yeah, that could be a condition.
Yeah, bottom
Paul,
line
my
is-
recollection on that one is, this is Jason, is that Nate and Ray would double check if that was doable. And if it was doable, the applicant agreed that they would do it. And so essentially the condition was, well, if Nate and Ray approve it, the applicant will do it. If they don't approve it, then they won't do it.
Right.
That's my recollection of it.
That's
So
correct.
what, so there was concern by a homeowner about that, so that showed up. If that doesn't get done, what's the impact of what happens?
So I'll just speak from my recollection. Obviously, it's not legal and that homeowner may be here, but I think he himself recognized that it's possible it wouldn't be done because towns don't always allow things to connect into existing systems. And I think the sentiment was, and if he's here and you want him to speak, and then obviously you can ask him that. I mean, but I think it was addressed as much as it possibly could. And I think the idea was I'd really, really, really like it for this to happen. But if it's just not feasible from a Department of Public Works and engineering perspective, then I guess we'll do everything else we possibly can to make sure this is as stormwater management ready as possible. But I don't want to speak for that person. But the idea was for me, as he talked and everybody talked, that the condition ultimately really only could be that essentially it's up to Nate and Ray.
Thank you very much for listening to everything. I mean, I had a lot written down here. I just want to make sure that we got it before we start proceeding with the approval.
Any
of
other
this.
If that's to me, yes, I'm trying to write down as much as I can. I'm not writing much down right now because I'm in my car,
I hope
but so
not.
that I can keep track of. I'm stopped now. I'm I'm in the economy parking garage, but I tried to keep track of everything that was discussed so that we could efficiently say, is it still a concern? Not a concern. If it is it addressed by a condition? And I had provided that, Paul, and I know you were looking for stuff in writing. So you may have from me, hopefully have from me, basically all the conditions that were discussed on April 10th, and then all the issues that you guys talked about as sort of a almost straw poll. Like, is it still an issue? We've heard from the public. Traffic, no. Access, no. Affordable housing, no. Steep slope, no. Water was one that we're talking about. The HOA issue was a condition subsequent that we're talking about, easements, etc. Environmental concern, no. And then I think one of the other ones was the possibility of larger homes that OJ felt fine with, but I don't want to speak for him. And then there was the odd layout thing that OJ said was a non-issue. And then the possibility of cutting off access to conservation land, which was a non-issue. So that I've sent, and the idea there was, let's agree with what we are done with the discussion on, but focus on anything that is still an issue for the board or the public, so that, to your point, Paul, earlier, we have all the information we need to make the right decision. And so I think we're in a good place for that now, but there's still maybe some questions, of course, but that's up to the board and the public.
So can I also ask, did we deal with the landlocked lots under 674-41? Is that, how is that being dealt with here? Did I miss that? I heard you talk something about it, but I'm not sure how it's being dealt
Get
with.
away with that in the latest revision on 4E.
Okay, so there's no more landlocked lots.
No more landlocked parcels.
brought that up the last meeting.
So just for the board's consideration, I hate to cut in. I do, just because don't want to be stuck and miss my plan. I do have to leave promptly at 7 so that I can get checked in and don't have anxiety over that.
Okay,
So, they already canceled one of my flights on me and rescheduled it, which caused me some issues. So I want to make sure if there's anything super legally specific that I can attempt to answer in the next 7 minutes. And I apologize. It is, I guess, what it is. I picked the latest flight I could to be able to help out a little in this hour. So any questions of really important legal nature?
anyone have any questions
For
for
me.
Jason at the moment? Any questions? I know we're gonna go through the potential findings of facts. Does anyone have any questions for him on those?
I have one.
Yeah, go ahead.
You mentioned about cutting trees for view in the wetland. 'Cause when I worked with the Forest Service years ago, in timber, we had certain restrictions we could do, how much we could cut in wetland. Certain types of trees, the basal growth, et cetera, if you know what I'm talking about. Are you within those confines?
So the short answer is the easement would allow for the cutting of trees
I'm
for,
talking about from the state point of view upon
oh,
cutting wetlands.
well, we obviously have to abide by whatever the state requires. I don't know. That's one
Okay, I'm
engineering
just
question
checking
on
if
that
you had
side.
looked into that. 'Cause along the river, with wetlands along the river, it's a different scenario. You won't get
Oh, I
so much percentage of this year, so much percentage next year.
Oh, I know what you're taking the Shoreline Protection Act. Yeah.
That's a different.
I'm not trying to tell you what to do, but you might want to look into it before you start getting to that scenario.
Thank you. It's
I'm
a
not
fair,
trying to,
a fair comment. Yes. With respect to shoreline protection for ponds, streams, lakes, that kind of thing, they look back a certain number of feet.
I'm not
you
sure
can-
that pertains to wetlands also, but I just want to
Thank you
bring
for
that
raising.
up.
I don't believe it does, but we'll let our engineering group handle that part.
Yeah,
Thank you.
We'll double check it. but-
Okay.
Yep.
Anything else? All right, so last meeting, we said we'd have some more public comment on the most recent plans were submitted on 4/8. I'll take a motion, open public comment.
So moved.
Paul, any second?
Second?
All in favor?
Aye.
Aye.
May wish to, may speak. Yeah, Gary, can you state your name?
Thank you. My name is Gary Castellino. And well, Jason is still with us. I just wanted to double check one thing about how much time we have for this. I double checked and I'm not sure if JCB in his car or whatnot, but look.
Excuse me, Jim,
Yeah,
would it be possible, it's hard to hear, Mr. Castine.
Use the
on
speaker
here,
over
it-
here.
would it be, no, I'm just saying, would it be possible to use my microphone?
yeah,
And
no,
just bring
use,
it
yeah,
down
there's
to
a
right here.
microphone there, just turn it on.
Just push the button in the middle. Good.
Thank you.
Thank you.
Thank you, Mr. Baldwin. I'm wondering about how much time the board has. I double checked, I have the advantage of the ability to double check the agendas and minutes while sitting here. And it appears that the application was deemed complete on March 13th. And that's when the 65 days would start running. So we're only here about 6 weeks into the 65 days, and 65 days is over 9 weeks. So it seems that there should be like another 3 weeks or so. But we're counting 65 days from when the application was deemed complete, which is March 13th. Isn't that correct? That's, I guess I should address that to the chair.
Yeah, 65 days from, I have to look, was it March? I have to look at the date we accepted it as complete. I don't have the minutes right in front of me. Jason, do you remember when we accepted it as complete?
I'm pretty sure it was at that March 13th meeting.
Okay,
And if I did yeah, it's a set number of days. And so it's possible that I miscalculated on the calendar, but it's the 65 days from the date of acceptance as complete.
it's
And
roughly
so
May.
if somebody,
So you said May 12th, but I think it might be a few days past that.
I'm trying to think, it's maybe when I looked at the calendar, I did 60 instead of 65 for some reason. So I don't
Yeah,
think it would be
sounds
more
like
than
it's-
5 days past that. And if that's the case, then my apologies for just looking at the calendar wrong.
No, that's okay. I mean, it
Um,
sounds like he's right. It might be May 17th or May 18th. But we
Sure.
don't- Okay,
Okay, yeah, so that would be like May 17th or May 18th as opposed to May 8th. So it's plenty of time for this board to have another meeting if there needed to be one. And while there is actually another issue that I don't know if I have enough time to get into it with Jason's being here, but first I wanted to say every time the applicant has come back, it's because something else has been needed. And Attorney Carey kindly acknowledged at the last meeting that the plan has been better as a result of it. So I'd like to thank this board. This board has found several things that were not correct with the plan. The plan has improved. It still needs more improvement. I think there's actually still a major problem, which perhaps Jason could weigh in on now if we have enough time. But I think
He's got
that it's been beneficial. So what I'm referring to now that will at some point, whether it's tonight or another time, probably require the opinion of town council, is a provision of the zoning ordinance or the land use plan ordinance, which hasn't been specifically brought up yet. It was alluded to indirectly a couple of times, but it hasn't been specifically addressed. And now that I've seen it and it's come to my attention, I do think that it's something that as a result of which at
could
least
you
two
tell us
or
what it is, please? We're running out of
Yeah.
time.
what provision is it? Yeah.
it's subparagraph 3 of the the definition of usable space or what is excluded from usable space. So most specifically, and I have copies here for members of the board if people want to look at it. May I approach the chair?
You may.
What subsection did you say, sir? My apologies. I want to write it down because I do unfortunately have to leave, but that way I can maybe look at it on the plane.
So it's under Article 8, in Section 8, Board of Adjustment, then the subparagraph 2A, adequate usable space. It gives a definition of usable space and it says what it excludes. Now, subparagraph 3 says it excludes land covered by wetlands, water bodies, watersheds, and drainage systems as defined by the New Hampshire Wetland Board's rules. So this is significant because there are probably 2 or 3 or perhaps more lots on which drainage systems are being used to meet the minimum lot size requirements. Now,
If I may, this is criteria if someone applies to the zoning board for a special exception.
well, I can
Okay.
address that. Well, we'll need to get opinion of town council on that too, but I can give you several reasons why I don't believe that is the case. First of all, this planning board, by the way, did, as you will remember, this past August, and I read the minutes from the August 23rd meeting, as well as heard the video of the August 23rd meeting. The definition of what is usable space in this section is, from my understanding, based on the opinion of legal counsel, based on the opinion of this board from past meetings, based on this board's review of the zoning ordinance, that this definition has been deemed to apply to the entire zoning ordinance, and it's not limited to what's required for a special exception. As a matter of fact, if you look at it carefully, you'll see that even to grant a special exception for lots for which a special exception is allowed under the land use ordinance, it still has to meet these requirements. These requirements aren't an exception to an exception. These have to be met even with a special exception. But in any event, wetlands have been excluded, but drainage systems have not been. And this, in the minutes, I'll quote from the minutes of the August 23rd planning board minutes. It's just a sentence or two. It says the planning board discusses stormwater systems and that stormwater systems should not be considered usable space or be part of the calculation for lot coverage, end quote. And if one were to go back and look at the video and listen to the discussion there were board members here who adamantly expressed the opinion that drainage systems should not be considered usable space to meet the minimum lot size requirements. And one board member in particularly notably noted that people could try to build a house on top of a drainage system. So this board, in reviewing those ordinances, when you were deciding what needed to update and you were conducting a general review, you felt that this definition was appropriate, you wanted to retain it, and you kept it. There are also other places where it's been noted that the definitions here,
You know, I don't want to cut you off. I think, Jason, you're at your limit and when you got to leave. so
I am, and I'm like, the heartburn is increasing. So let me say this one thing, which is, to this point, if the board reaches the conclusion that that definition does apply, then there would have to be some analysis of whether systems are included in usable space. And if it is, then that might lead to the situation where some lots would not have the required space, and that would potentially require a change or a denial and a review. And I don't mean to throw that wrench out there, but obviously, in fairness to this gentleman that's making this point, it's up to the board to decide if that definition applies. And if it does, and if the board makes that decision, then they would have to apply it in a way that may very well exclude some lots. And so I don't have enough information to make the decision. I certainly apologize that I have to scoot out. But I'm happy to look at that later. If it's deemed not to apply, then it's a non-issue, and you don't need to get an opinion from me further if the board makes that decision today. But if it's deemed to apply, then that would be something that would require a little bit of further analysis. So I'll have to leave it at that for today.
Okay, thank you, Jason.
Thank you, Jason.
Thank you.
Safe travels, Jason.
You're welcome. Thank you, and I'll see you all later.
Yep.
Good evening. Bye.
thank you. So it's unfortunate they have to make this point right after legal counsel just left, but it seems to me that the decision about whether or not a provision of the ordinance applies or not is in part a legal decision and not just a decision of this board. And there are a couple of places where this has been discussed before. For example, at the last meeting, all right, on April 10th, just 2 weeks ago, Attorney Dennis was part of the conversation there. And there was a discussion about whether or not the steep slope provision in subparagraph 4 applied. So this is the same section of the ordinance that has a steep slopes definition. And Attorney Dennis pointed out that one issue there was the Department of Environmental Services didn't have a definition of steep slope. I'm sure you all remember that. So he indicated that from an appeal standpoint, that the absence of a definition, steep slope, could be an impediment to an appeal. However, he didn't suggest that these definitions don't apply. I think the planning board has been operating under the assumption, and as I've seen from minutes of other meetings, that these provisions do apply. And this is simply where the definitions are set forth. In fact, there was an
You know, you
agenda.
already brought this up, steep slopes, a number of times.
Well,
so
I'm
this
not
is-
bringing up steep slopes again. I think you're, sorry, with all due respect, I think you're missing the point that it's
Your
the,
point is that this section of the ordinance applies to this application.
yes, I'm
Yeah.
not re-arguing steep slopes.
Mhm.
I'm
Good.
saying that the ordinance applies, and that was acknowledged by Attorney Dennis at the last meeting when he was discussing the steep slope section. That's all. Also, in agendas of prior meetings, for example, February 28th, it was mentioned that it had been considered duplicating the definition of usable space and adding it to the front where the definitions were set forth to make it easier to find, which was recommended by the town attorney. And the agenda said there's no changes. What is required, the standards will be easier to find and access. So this is where the definition is. Now, I'd like to move ahead and say, Mr. Robinson was spot on with an observation that he made at the March 13th meeting, I believe it was. And he raised this very concern about counting the drainage systems as part of the usable space with respect to lot 24. Lot 24 is the lot at the end of the White Birch Lane extension, and it has an infiltration basin on it. By the way, when it comes to the drainage systems for this development or these developments, the principal drainage systems, I'm sure you know, are 2 infiltration systems, one on lot 24 and one up on lot 6, which is the top of Valley View Lane, and 4 rain gardens. So that's basically the main elements of the drainage systems that we're dealing with: 2 infiltration basins, 4 rain gardens. Mr. Robinson pointed out that there was a concern about using usable space, which is not 4 non-contiguous areas, and more than half of one was consumed by a drainage system, whether or not that was appropriate. And by the way, although that lot is over 1 acre, it's just barely over 22,500 square feet of usable space after excluding the wetlands. So it's a minimum usable space lot as it is. So I'd like to just take,
15,000.
it's got a duplex on it, which is
Duplex, okay,
22,500.
20,000.
Yeah, thank you, sir. So if I could, I'd just like to raise the question Mr. Robinson read. I wrote it down verbatim from the video. He said, just a couple of things that I can't think myself through. Let's start with lot 24, where you have a duplex. The calculation of usable space for that particular lot is 4 non-contiguous areas that surround a single area of wetlands. So you are calculating the usable space by taking the parts of that lot that are outside of the wetland area. And with that, it meets the criteria. But of those 4 separate areas, only one is large enough to actually do anything with it as far as construction. And there's a duplex on it. But nearly half of that one, quote, usable space, is taken up by a drainage structure. And I guess I'm just questioning the counting of what is right now not flat, but undisturbed usable space. It's definitely usable space right now. But once you dig that up and put rocks and drainage and dump water into that, should the board still consider that usable space? I need to be talked into that.
Ask him a question.
Go ahead.
There's a lot of this drainage space on 50-foot right of way or totally within the lot. So the right of way, it doesn't count. Am I right? If the part of the drainage is going in, is in the right of way for the association, is not counted as part of the development number of square feet for that particular lot, am I right?
The wetlands we took out, we did not take out the drainage.
But he's telling me the other drainage coming, the basin down on the other end.
Yeah, so we had this this was back 4 meetings ago, we had this conversation about what areas would back out. And it was determined by the board at that time when we were doing our design that would back out the wetlands. We actually talked about stormwater treatment facilities, and it was discussed that we would not back those out. I mean, before we went and designed everything. So,
I just
I mean,
wanna-
that was, I don't know if it's made into the minutes, but it was on, we did discuss this.
I just wanted on the record, so.
Yeah, so I don't remember, I can go back to my notes, which meeting it was, but it was definitely discussed when we discussing you mentioned that we had to back out the wetland areas,
Okay,
which we did.
If I may, I don't believe that was discussed at a meeting. If it was discussed
It
at
was
some,
discussed at a meeting, excuse me, but it was.
that meeting.
well, I know Mr. Robinson raised this question at this meeting. I just read it on March 13th. And the answer that was provided by the applicant at that point was alluded to where the applicant lives in southern New Hampshire. They have 1 acre lots, and that's because they need wells and septic systems. Here in Lincoln, you don't need wells and septic systems, so it's not a concern because there's plenty of room. However, the rest of this lot is being taken up by a drainage system. And here in Lincoln, we may not need wells and sewage systems and septic systems, but we do need drainage systems. So you've got about half of the small available usable space on this lot being taken up by a drainage system. And if a town official said you don't have to back that out, and if that was contrary to the terms of the ordinance, that would not be binding on this board. And I believe that this board needs to follow the terms of the land use ordinance. And it says that not only wetlands have to be backed out, but drainage systems have to be backed out. Now, I think that will affect a few lots of the subdivision. It would affect lot 24, clearly. It would also affect lot 6, which is at the top of Valley View Lane, top of the road to the left. That lot has, lot 6 has 23,247 square feet for duplex.
Gary, I think you're really digging here, and if you're gonna go with that and say that the stormwater pond on lot 6 is too big, I'll just add it for lot 2. I've got an 1.5 acre lot at lot 2, move a lot.
Well,
so it's real easy to do.
It,
Again, if you have constructive comments, if you wanna work
Okay,
together.
you know,
I'm here to
sir,
do
all the
it.
comments have to go to the board. Don't cross-examine them, please.
yeah, thank you. So it's gonna, without excluding the drainage systems, it's got about 750 extra square feet, but that infiltration in the back of the lot probably takes up about 2,000 square feet. I didn't find exact dimensions, but it can be estimated around 2,000 square feet, which would put it about 1,000 square feet short. And that's not even counting part of the rain garden that's in the front of the lot that also would have to be backed out. So lot 7, I think also would have a question about whether it meets the minimum space after the halves of 2 rain gardens are taken out. That has just 500 minimum square feet. Now, there are solutions to these in terms of being, constructive solutions. For example, at the top of Valley View Lane, there could be one less lot. So if you took the perimeter of the, it's not that hard to do. If you took the perimeter of the existing 3 lots, the outer boundary line, and by the way, that would also preserve those long sections of land which aren't going to be developed far to the east, so that because those aren't developed, as Mr. Robinson pointed out, that actually helps the reduction of water flow downhill. And if you divided those 3 lots into 2 lots instead, there would be adequate room for the drainage systems to be excluded from the minimum square footage requirements. And it would simply be either 2 single-family houses, or there would even be enough for 2 duplexes.
Okay, so what are these 3 lots again? Lot 24, lot 6.
The 3 I'm referring to are 6, 7, and 8 at the top of Valley View Lane.
Okay,
Those 3 lots have 3 duplexes, and they're very congested as it is. And I don't want to go back over things I've talked about before, but
so
actually-
let me ask you this. You're suggesting lot 6, 7, and 8 instead of 3 lots, there only being 2?
Yes, sir.
I may ask if they were to do that, would you drop your opposition to the project?
Well,
I mean, there's no right or wrong answer. I'm just asking.
yes, I still have concerns about the project. And by the way, there's, to meet the ordinance, I believe they also have to take care of that lot 24 down at the bottom of the hill, which they could do in a variety of ways. One way would just be to have one less lot, make it part of the adjacent lot, whichever that is, just not counted as a buildable lot. So that's a pretty easy solution too. They could just take out a boundary line. I still have some concerns about the project, and I honestly, to answer your question, I don't know.
Okay.
Really is
okay.
the most honest answer I could give you. But I do think that these things have to be done, and it's not anybody's fault. It's not the fault of some official that didn't bring it up earlier about the drainage systems having to be excluded. It's not the fault of the applicant. It's definitely not the fault of the engineers. The engineers have done an excellent job. I think it's inherent in the land, and perhaps it's just because the land is a problem. It's very steep, it's very wet, and it's hard to get this many lots on this land. So a little less aggressive approach would perhaps meet the ordinance. So I don't want to take up too much time, but there are just a couple of other things I wanted to get into.
We want to give everyone a chance to speak.
Yes.
So let's.
Yes. So I guess just to be complete there, I could give more if needed, but I think it's been adequately documented in past meetings and in minutes that these definitions do apply. So I believe that the board is bound to exclude these drainage systems, and perhaps it's unfortunate this didn't come up sooner, but I think they have to be excluded.
Okay, I would like to point out the section you're referring to, the voters, it was put on the town warrant to move it to the front of the ordinance, and the voters rejected it.
Yeah, but it was also in the in the explanation in the minutes of this meeting, it was said that putting it there wouldn't have any change of legal effect. It would just move the definition from one section to another. So this board, I think, has been on record as saying that it wasn't going to be of any legal consequence, but this board was concerned about the steep slope provision, which understandably is a concern because the board hadn't really developed the definition of steep slopes yet. So I think that was understandable that the board had some concern about that. But the agenda for the planning board meeting, the town warrant, the agendas of the planning board, what was indicated in the materials and agendas as being the advice of town council at that time was that moving the definition would not have any legal effect. It would just make it easier to find. So my understanding is that these definitions do apply. This is the place where usable space is defined. And it also is the place where things that are excluded from definition of usable space are set forth. So just a couple of other things, and I'll let somebody else speak. On the issue of conditional approval, I've been hearing a couple of times people alluding to it as conditions subsequent. And you're probably aware that there are two different ways of doing conditional approvals. One is conditions precedent, one is conditions subsequent. So if at some point this board were to get to the point of giving a conditional approval to this development, and Frank has brought up at many hearings, is that after conditional approval is granted, the public never sees it again, and maybe even some board members never see how the conditions are met. But I would suggest to the board that the way to handle that might be to approve any conditions as conditions precedent. And I think town council would probably indicate, and it's in the statute, RSA 676-4, that if it's a condition precedent, then there has to be another hearing at the end after the conditions are met. So that way, all the members of the planning board, all the members of the public will get to see exactly how the conditions have been met. And there are some significant issues. So there could be a dispute about whether some conditions involve discretion or judgment. If they involve judgment, then there has to be another hearing. If they're just discretionary acts or administrative acts, then there doesn't have to be another hearing. But you can eliminate the dispute about whether they're matters involving judgment or matters involving discretion by simply making them conditions precedent rather than conditions subsequent. And then you don't get too far down the road before the public getting to see how the conditions are met and the board getting to see how conditions are met. I think that is about it. Except for one last point. So the solution that I'm offering at the top of Valley View Lane, making that 2 lots instead of 3, solves another problem too. If you look at the rectangular area at the top of Valley View Lane, which is lot 7, 8, it's the middle lot.
Lot 7.
Lot 7. If you sort of make a rectangle about approximately around the area that's at the top of the road and you leave out the large section to the east that extends down. My reading of the dimensions is that you really only have about.
No, this has been on a couple of sets of plan, this configurations, nothing's changed.
Right.
So, I mean, we've already,
Yes, I just wanted to tell you that it's going to be about 7,000 square feet. That rectangle will be about 7,000, and you need about 22. You need 22.5 to be a duplex. So they're relying right now very heavily upon that other about 16,000 square feet extending far to the east. So it isn't really. So I want to say that backing out the drainage would solve 2 problems. It would meet the ordinance, and it would also make it more aesthetically acceptable to the neighborhood by having only 2 lots up there instead of 3 very crowded structures relying upon those other parcels. And again, I want to thank the board for its thoroughness in examining this application. Well, I have to say, thank you.
okay, thank you.
Would you mind if we provide a quick response?
Sure.
With respect to the drainage and calculations, 3 points. 1, this has been discussed and decided by the board previously. That's why the plans were designed the way they were, based on the representations by the board as to how you were going to approach it. So I would suggest that we not readdress it and basically have them redesign plans now after having made that representation previously. 2, it's all really moot point anyway, because the provision that he's citing relates to special exceptions. We are not asking for a special exception. If we were, we wouldn't be before you. We'd be before the zoning board. And the zoning board is the one that considers special exceptions and what requirements need to be met. So second point is it doesn't apply anyway. We're in the special exception realm when we're talking about that, and that's not what we're doing here. And then the third, as you pointed out, the town has made a decision on this. Even if the board had considered it previously, the town has spoken, saying that they don't want the special exception provisions to be moved outside of the special exception realm, and I don't think it would be appropriate here. On to the second point about conditions precedent or subsequent. The way I look at these and the way I think most towns do is this. If there are conditions imposed that you believe you need to provide additional guidance on and want additional input on, then those are precedent. In other words, the conditions approve it, you got to come back to us because we want to review something. The condition subsequent is usually ministerial in nature or technical in nature. In other words, things like Ray, making sure that the right notes are put on the plan and the right height is referenced on the stone, the retaining walls and that kind of thing. Something that if all that was going to happen was Ray was going to come back and say, did he meet the technical requirements? And Ray said, yes, that is a perfect condition subsequent. There's nothing really the board needs to do. It can rely on the expertise of the consulting engineer. And the same on the legal side of things. I mean, it makes no sense to tie this up, to have Jason and I work through the easements, and then for you to say, Jason, do you agree with the easements? Yes, I do. Okay, thank you. Unless you guys are going to put in some legalese with respect to our documents. So my suggestion and recommendation is that all of these be conditions subsequent. If at any point either Jason or Ray says, boy, this is a close call, I really don't feel comfortable making this. This is beyond the technical side of things. They can always say, we need to have the board review this. If that happens, fine, but it typically doesn't. Usually things are all ironed out at this point. So that's my suggestion in response to the comments of the person who spoke just a moment. Thank you.
Thank you. So Matt, Linda,
Good evening, everybody. Matt Leidner, 75 Manor Drive. I just wanted to quickly say thank you for acknowledging my concern expressed at the last meeting about connecting the drainage overflow or outflow from that basin at the end of Mansion Hill Drive into the Mansion Hill Drive drainage system. I was happy to hear tonight that it looks like that's still going to be discussed with town engineer and I guess there was another name thrown out, which I presume is a DPW person. So I appreciate that. I would just ask respectfully that when the question's posed to the DPW, if it can be done, kind of with the full context of the matter, because I think the knee-jerk reaction from DPW would be, no, you can't tie into the drainage system, but just that it be presented so that they understand what the alternative is, which is that it discharges, into my yard, basically. So that's all I would ask, and I understand that the DPW will decide what they decide, and that's that. I would also ask that the planning board consider a condition that if DPW says no, that connection cannot be made, that perhaps the town council weigh in on whether an easement would be needed in order to discharge that water from that basin, the basin outflow onto the abutting property. Because it would be going from what, that water, some of that water flows, through the woods and overland onto our property, but this is more of like a structural outflow onto our property now. So I would just ask that if that connection cannot be made, if there can be a condition that town council weigh in as to whether an easement would be appropriate. That's all. Thank you.
Sir? The catch basin he's talking about, is more water going to be coming out of that as a result of this project?
So again, we made revisions back and talking with that comment, right? And then with review with Ray, and we revised the proposed drainage models to analyze that point exactly. So at that one point, we split up drainage point, I believe it was 1 to a 1A and 1B. And there's actually some concentrated flow that comes in now. There's actually an existing swale that actually, but the runoff runs down that hill and actually runs in out. Per our review, our drainage analysis, it's less than or equal at that point, not along that whole property line where originally we were calculating. We're talking about now actually at that point where he's referring to that goes to his yard. So the runoff is less in the proposed condition than the existing condition as presently designed.
And that's still for the 50-year storm?
Yes.
Thank you.
Okay, Frank Prosciutto.
Thank you. I just want to follow up on a couple of items. I did submit another letter to the board. I don't know if you received it. I'm not sure if Carol was around or not.
We didn't get it, unfortunately.
Okay. I won't read it now. I'm hoping that this will, again, there's so much being discussed still. I want to address the issue that this is taking too long. This is a very complex proposal or this on land that is also very complex, and that was acknowledged by everyone during this entire process. So I do also appreciate the fact that the board has spent the time it needs to make, and that there's great interest in making sure it comes to the correct decision. I want to take also disagree, I guess, with Attorney Lick in that the definition of usable space within the context of the is it the variance board, whatever.
Back and forth. This is just redundant.
No. Well, but he's saying it's wrong, and it's not. It's saying that the Board of Adjustment cannot use any of these. They can't create a variance on those. They can't say that the usable space. So we'll leave it to the town's attorney to weigh in. But I'd like you to please consider the fact that there is an understanding that usable space includes this definition for all sites. And I understand that you've dismissed the steep slope provision. in just somewhat, I just want to say, the board, I think, has been very good about listening and trying to work with the developer on coming up with a good plan. I still believe, however, that the plan raises issues for the community. And you've tried to work with them a great deal, and it should be acknowledged by the developer that you provided a lot of good information to make it a much different plan than it originally was. I do want to say that the density and what's going on here, and I just want to go back to the quote traffic study, and I'm not talking about the study given that says, can the roads handle it? I'm talking about the concerns by the citizens, the people who live here, that the traffic and both from ongoing after the project and during construction, and I appreciate that. I believe there's one of the conditions is going to be that the construction vehicles and workers are not going to be able to use the streets. But you know, this particular plan, unlike anything at South Mountain, is impacting directly the people who live in this town. You're talking about, everyone has heard a lot about the fact that the townspeople are diminishing and are being pushed out and are difficulty. This is a community of carpenters, plumbers, people who work in the town. And they've said it before, and I understand that the board can't decline this, I guess, simply because of this. But I think it merits a conversation with the developer that the impact on this is that this no longer is going to feel like a neighborhood for these people. They're letting their kids play in the street. The fact of the matter is that we're not worrying about, oh, the street can't handle the 50 visits a day or whatever it was. I don't care. It's that you're changing the very nature of the neighborhood. You're making it so that these people will say, you know what, I'm going to cash in and move to another town because there are no neighborhoods left. This particular area is being developed in a very sensitive part of the town. It's where the townspeople live. And it's not, again, on South Mountain, the concerns that you have about steep slopes and water and whatnot, it's just going to impact the folks on South Mountain and potentially down to the river. The impacts of the water issues that may be created, and we know there's lessons learned from, and that's part of my memo, and I'm just going to leave it. Hopefully, again, someone can take a look at it. There were concerns raised by Ray Korber about whether or not, you know, the capacity that we're currently looking at is adequate. And we learned from it in the Forest Ridge. And I know that the town's attorney said that, you know, the board can learn from things that didn't work and not have to make the same decisions. And so I do think that there's need to look very cautiously, and you have been, and there's been a lot of pushback that the HOA can take care of it. And look at this disparate system that they're set up and making sure that it works, but it's really strained. They're asking a lot, and it's not what is being asked in other areas of the town. It's being asked for this particular area that has so many things going on with it. So I appreciate that you've really spent the time. I think, you know, it's worth a second look at some of these things to make sure it's right because of the impact it has immediately on the very people that abut this property that are long-term residents. And again, I'm not going to read my email. I'm hoping that this, what I have to say does get reviewed prior to, however, any approval.
Okay. Thank you.
Thank you.
Would anyone else like to speak? Tammy? I think you're gonna have to take Paul's microphone, please.
Gee, looks like a Bowden.
Just push, yeah, there you go.
Okay, yeah. Tammy Jeanette Dutilly. In previous meetings, there's been suggestions twice that the board, all the board, walk this property. Has anybody done that yet?
I haven't been up there.
You haven't been up there, Danielle? I know she's,
I'm like you, I lived on a property growing up.
okay. So I would like
done that.
everybody to walk this
That's
property.
Paul.
Hey, Paul. So anyways, they all have heard me plenty of times. They've heard everybody up on Mansion Hill that first packed this room at the beginning and now go to Zoom. They're all against it. And I've heard the owners say, you know, if they have to bite it off, it's a wash, it's a wash. I think, my opinion, I would like to see the board reject it for multiple reasons. But if they don't, maybe respect the ones that say they do not want this taken.
Tim, your microphone's not working.
It's green, Paul. Maybe your microphone's not working.
Your button push?
It's.
Yeah, it's on.
Okay,
It's not working.
get the mic closer to you.
Can you hear me now, Paul?
I can, just like
All
everybody.
right.
Thank you very much.
You're welcome.
Telling Jane.
So anyways, in all due respect to the abutters, and so it's not a total wash for the developers. Where the developer, I don't remember which brother was here at the time at the last meeting, but would not commit to the price range of the houses. So it's not a wash and they don't have to bite off buying property that really shouldn't, in my opinion, be developed. Cut the development down. I believe it was 28 originally for buildings.
34.
How much?
I went to 30 plus originally.
Right, but
They've given up quite a few lots.
we're at what, 28 now, I believe.
28 units.
So cut it down to half of that. They're still going to make profit, not the profit that they want, but they're still going to make a profit. They're going to get their money back for the land. It will cut down on the impact on the roads, the traffic. It won't take care of all of us that are against it, which you go door to door up there, you're not going to get, yes, they want this. Compromise. Respect the developers, but also respect all the abutters. Allow 12 to 14 units, houses, whatever you want to call them, because we really don't know what they're going to be because no price range was really put in there. So they can make their money back. But it's not impacting 100% of what they were proposing to all the abutters. And then meet in the middle, compromise. Then it's not everybody wanting to strangle everybody, but working together and hopefully being so it can be a respectful, added community, not a resentful for life community. We do need people living here with all respect to the elders, which I'm not too far from there, or probably am there now, I don't know. But anyways, in all respect to everybody, let them keep their livelihood, but don't strangle them. So if you do let this go through and not listen to everybody that's up there, let the developers have half of what they want. It's not disturbing all the land, just part of the land. And just show respect for everybody. I'm not trying to harm these people because they will make their money back. You know that as well as I do. But it's not going to be overkill for all of us. And that's all I have to say at this time. I just wish you would really, really respect the whole situation. And as far as all this, I hear that it doesn't matter that our water is not strained, our sewer system's not strained. You won't ever hear me agree with that because I've heard it plenty of times at selectmen meetings about our water system. And for some reason with this development, all of a sudden those problems have gone away. I know with my showers, I know with my washing machine, there has definitely been an impact on our water already. You let that full development go in, it's going to be even more strained and it's going to be more expense to the town in the future. So I just hope you listen, all of you listen, and realize that it can be worked out for both parties. Not 100% of what either side wants, but it can be worked out. And I really hope you take that into consideration. Thank you.
He's asked a question. Is it something you'd consider?
I would, I guess I'll let the client speak for himself, but for 6 months in, the answer in my view would be. And the bottom line is, if we meet the requirements of the town, there's no need for us to concede even further, especially at this late stage. Go in and cut everything.
As noted in the preliminary concept plan, I think we had 35 lots. Now we're down to 25 lots, so we've already actually cut back quite a bit. That's right, but we've already actually cut back quite a bit on the development. There's several lots out here that are tremendously larger than all the other lots that are up and down Valley View Lane and Mansion Hill. So make the argument that this isn't dense at all, and there's actually several lots, and we could put more on that would actually meet the town requirements. And again, we're not asking for any waivers, meeting all the requirements.
Would anyone else like to speak? Is there a motion to close public comment?
So moved.
Again.
Joe, second, all in favor?
Aye.
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 Okay. Pleasure of the board proceeding. Ready to make a decision?
Jim,
Yes, Paul.
I'd like to know the date that, the deadline date that we have here. Is it May 8th or is it May 17th or 18th? We've had. Can we figure that out so we know?
Get on the calendar.
I'm looking at the calendar now.
We meet
I
on,
think it's May 17th, as far as I can calculate.
next meeting is May. We have 2 days after.
So you think it's May 17th?
That's what I get too, by the way. Okay,
What do you have?
I just didn't know if you included March 13th as
I
day
just-
one or March 14th as day one, but it's either gonna be the 17th or the 18th.
All right, so I guess, Jim, then my question is,
I mean, we have time for another meeting if you feel we need to. You're not ready to make we're not ready to make a decision, that's fine.
I only have truly one other question, that probably needs, Jason Dennis to weigh in on. And although I do realize that I think we talked, I haven't gone back and looked at all the videos yet, but I mean, as far as the stormwater management or the drainage issues that we should have maybe considered, but we didn't. I don't know whether that's relevant or not. And while I do appreciate Mr. Lick's interpretation of it, I certainly would like to have Jason Dennis weigh in on it. To see what he says.
Okay. Does anyone else have any other thoughts? Steve?
We have a couple more weeks. I'd love it.
We
We need it. I think so. I'm just concerned about where's the water gonna go? There's like $8 or $10 million worth of houses below. That's all I care about.
Can I speak to the drainage, if that's what you're referring to? So again, we've gone over, this has been discussed numerous times, and as we provided in the stormwater report and the plans, we're meeting or decreasing the peak runoff and volumes for the town requirements at all the discharge points has been fully reviewed by Ray, peer reviewer, and there's actually no comments about really talking about stormwater at all. So there's nothing else to do with this, the stormwater. There's no more action for us to correct or to revisit.
I think that's the obvious problem though. Where does it go? It goes in the ground. It's not gonna go uphill.
No, that's the comparison, like that's where it goes now. So we're actually mimicking that. And then what you want to reduce is the flow, like for example, to the neighbors that runs off surface. And that's what we are reducing and required to per the state and the town regulation. So I'm not sure there's really no open-ended discussion points or things to address of that.
My view is you either accept the opinion of your consulting engineer and our engineer who an agreement on that, or you don't? I
Tim?
mean, if we have another meeting, there's nothing else we're gonna do, and there'll be no other information that Ray will provide.
Paul,
Yeah, Jim, again, Jason and Ray, Jason had to bug out tonight. Ray's not here for another reason. It certainly would be nice before we close out something of this importance to it. I would like to be able to hear from Ray. I'd like to be able to hear, and I know we have stuff in writing, but there's been comments that were made tonight that I think Ray could weigh in on. And there's also been a question I think Jason should weigh in on. If we make the wrong decision tonight, we could be challenged, probably be challenged anyway, who knows? But I think we owe it to ourselves to make sure that we investigate any remaining board questions prior to making a decision. I'm ready to make the decision tonight if you really want to, but I think the fact that we have time to be able to at least investigate some of these other things and hear from Ray and to hear from Jason on these issues, I think is, for me, I'd rather wait at least one more meeting and try and get those guys here and tell them they need to stay here and they need to be here, or we need, if Ray can't make it, then we need to get another engineer. Because Mr. Lick is right. These guys have gone through a lot of meetings and they've been good, and so haven't the people who are building up there. But we need to make sure and try and do this as right as we can. And I think
I suggest that you have heard from your engineer and you have heard from Jason. Your engineer's now provided 3 technical reports. None of those say that there's any issue with drainage or he has any concern with the drainage plan. And with respect to Jason, who's put together a proposal for you tonight and a list, and none of those does he say that you are to review section 3 in the special exception section for zoning board review in the context of this application. I'd be surprised if he did, because I sit on my town zoning board. I'm the chair of my zoning board. We do special exceptions. We do variances. I know how to read ordinances. Planning boards do not do that. And I can tell you, my planning board does not turn to the variance and special exception section of my ordinance when they're reviewing site plan review. It sort of, you might as well say, well, I need somebody to tell me that we don't apply, Federal Highway Administration regulations either. It's not what you guys do. So I don't know how more plainly to say it. And I can certainly tell you, Jason, would have told you guys if we were to be using that ordinance. But again, you've got to make the decision as to whether what they've told you is enough, or you think you got to hear from them again. I get it.
Okay. ODW hand up?
Yeah, I just wanted to ask, Paul, what specific questions are you uneasy with that you want to talk to Jason? Is it just about the inclusion or exclusion of water retention structures in the county of open space? Is that what you're talking about?
yes, sir. I don't know if we made a mistake and we said something we shouldn't have. I'm not sure. And with all due respect to Mr. Lick, I'm a person that, you're the applicant. I'd like to hear from the person who's supporting the town. I feel a little more comfortable in that. That's one of it. And then Ray could weigh in on some of that stormwater stuff as well. He might be able to have a whole outlook on how much that really affects the law. Maybe it doesn't affect it very much at all. So I think having both those guys there would really make a difference. Now, OJ, I think we could proceed tonight with doing going through the finding of facts and maybe doing the conditions of approval. And then, it could be expedited so that, that the next meeting, all we're doing is a couple house cleaning items, and then we can make our decision.
Yes.
I would suggest that as the first step, let's go through the findings of facts. Let's go through the proposed conditions, and then let's make a decision whether we're going to vote on this tonight or
let's
up to the next meeting.
All right.
That would put us in a better position, I think, to make the decision about where we stand.
So we have 2 sets of finding of facts. One's the original and one that's been condensed by the town planner, town attorney. I'd like to go with that.
Okay.
This is, I printed this out myself.
Okay.
So this is an email from April 18th. Okay. You got it, Joe?
Jim, is that the one that has 26 findings of fact on
Yes.
it? Okay, thank you.
Right, you got it, Steve?
I read it several times tonight.
All right, so let's read the first one. The application is not contrary to the interests of the health, safety, convenience, economic welfare, or general welfare of the town and its citizens. Does you want to add anything to that?
Jim?
Paul?
I'm not sure if I look at this correctly, Jason has said that some, all of these or none of these may apply.
Right, so we
Um,
can use, these are just proposals, that's why I'm asking if anyone has any issues. You want to use it, you don't want to use it?
I'm not sure that this one we want to use. That's my opinion.
Okay,
We don't need, it's pretty not applicable.
yeah, we don't have to use any of it. We can make up our own, I'm just gonna start somewhere.
Use it or just use part of it, just does not apply, you know what I'm saying?
So again, we want to use it, not use it, make changes? I propose a change to it. Go ahead.
Can we say the planning board has listened to and considered the interest of health, safety, convenience, economic welfare, economic welfare and general welfare of the town and its citizens?
Okay,
I'll agree with that.
well, you might have listened to it, but are you saying it's not a problem?
That's what OJ said.
All right, say it again, please, I didn't catch it.
Planning board has listened to and considered the interest of health, safety, convenience, economic welfare, or general welfare of the town and its citizens.
Pretty much covers it.
I mean, many of those issues have been brought up in the public comment section, but I just think we should say that, yes, we've listened to them, we've considered them. It's not like we're ignoring them.
Consider them as part of our decision.
Okay, that at the end, and making our.
All right, anyone else have anything on that? Land at issue in the application is of such character that it can be used for the purpose of the application without danger to the public health or safety.
It says because, are you gonna put something in there, or is that, we just gonna use?
So, I mean, you can
Yeah.
either just put a period, not use it at all, because.
I guess the question is to whether some of these are gonna put us,
Just weighed in about the road widths. Weighed in about the road widths being 20 feet, you're okay with that?
Yeah, we're still working.
Again, you can put a period after safety, add because, or not use it at all.
I'd say put a period after safety. I mean, we could list reasons like the road width and the lack of sidewalks and. It'd be a lot less.
Yeah.
OJ, it's hard to hear you, OJ. I don't know why, but I
Please
can hear
all.
Jimmy.
Sorry,
He basically said to leave it as is, no because, health or safety, period.
So my question to, my question to you, OJ and Jimmy, is that if we are putting these in there, does that mean that we are substantiating it and that we are considered professionals able to have, make those decisions? I mean, that we have the professional expertise to make the decision that,
No, that's not what this is about. This is about the planning board going through some of these issues and stating that we've considered them. We're not experts, we're not engineers, but we've considered these issues and are either satisfied or if we make note, not satisfied with whatever the issue is. Now, we could
Alright.
list reasons like I said, the width of the roads, we felt was safe, the lack of sidewalks, we were comfortable with the safety of that, et cetera. But I don't know if we need to do that. For each one of these, list off every single possible issue. It's just that we've considered public health and public safety in our review of this project.
I mean, one of my list of conditions proposed review of access for emergency purposes by the fire chief. So that'll be a condition of approval over and above these findings of fact, if approved.
I would agree with that.
So would I.
One, number 3. Land at issue in the applications of such character that can be used for the purposes of the application without danger to the environment. Because,
We'll put a period, because if you disturb one rock, changes the environment. Scope, how much you're gonna change it.
is everyone good with that?
I am, yep.
Yep.
Board finds that either A, there is no meaningful presence of rock formations, presence of same does not render the land unsuitable for its intended use, or this standard does not apply because say,
Period.
sorry, Joe,
Running Ray made rock developments from that area. No cropping.
so
Put a period, does
So
not
put-
apply.
the board finds that there is no meaningful presence of rock formations and period.
Period. I agree with that.
I don't think we ought to include that one.
Okay. Go ahead, Paul, why?
Because I don't think we know for a fact that there's meaningful presence of rock formation. I just heard Damien Dutilla Jeanette ask if anyone's been up there and looked at it. And
Yeah, Jay has.
So that's why I didn't fill in the blanks. I asked the question that others,
right,
I mean,
You feel more comfortable just eliminating that as a.
yes, I would. I
yeah,
would eliminate
based,
that.
based on the public comment, no one has brought that up as a concern.
I would suggest, let's just cross that out, because
Yeah.
that hasn't been part of our discussions. I don't think we've discussed rock formations. Steep slopes we've discussed. I would say that B would be the meaningful second half of that sentence.
So the board finds that presence of steep slopes does not render the land unsuitable for its intended use.
Don't put a period there.
So Joe, what's that?
At that point you stop, put a period, and scratch out the rest.
Right.
Yeah, so I'll read it again. Board finds that the presence of steep slopes does not render the land unsuitable for its intended use, period. Number 6. The board finds that either there is no meaningful presence of any unusual surface configuration, Presence of same does not render the land unsuitable for its intended use, or this standard does not apply because. I don't think, same with the rock formations, it hasn't been part of our discussions.
Agree.
But everyone good with striking number 6?
I'm good with it.
Number 7 deals with flooding. See, there is, no one has mentioned a concern about the land itself flooding. But it hasn't been part of our discussion. So either the board finds that there is no meaningful tendency to periodic flooding period, or we can just scratch it out in its entirety.
I would scratch it out in its entirety. This is Paul.
In here.
I
Okay.
agree.
Board finds that either there is no meaningful concern of poor drainage. Presence of same does not render the land unsuitable for its intended use, or the standard does not apply because.
Go with
So-
D on that one. And this one, we should put a comment on this one saying, has been discussed with town engineers and their engineers to address this problem.
Right. So this is one of the things we've worked on.
Yeah.
We can't say there's no meaningful concern of drainings or drainage.
Hey, yeah,
What's that?
sorry about that, Jim. Could we put something in here that says that the board finds that there's been ample study done for stormwater management? And that we believe that it meets all the criteria for town regulations, something like that. So it shows that we've looked at the stormwater management portion of it and the drainage.
I think something like that would be fine. You just gotta think about it.
What do you think, OJ?
I agree. Can we go with? There's been ample study and review of stormwater management system demonstrating a reduction in off-site water flow in a 50-year storm.
It's not only a reduction, it just, I don't know if you want to say reduction. I mean, it's not
Well,
reduced.
That's what their report says. It's actually gonna shed less
Okay.
water. Once it's
I'm
subdivision
fine
is-
with it. I'm fine with that as long as that's correct. I just want to make sure that we were correct in saying that.
Looks good on paper.
some discussion about soils.
We know.
They gave us a,
Right now you go hand in hand anyway.
Yeah.
We didn't have a soils report, did we?
No, so I mean, maybe we gotta scratch 9.
I think I'd scratch that.
Fine with that.
I'm fine with that.
You know,
10 deals with,
we're the municipal water and sewer, so it's not applicable.
Well, it is that we find that there is not an inadequate capacity for sanitary sewage disposal in our system.
That's what I meant.
Right, so.
Yeah. I think I would say that the board finds that there is not an inadequate capacity for sanitary sewage disposal and public water supply, period. We can capture them both in one thing.
Good.
Does that work?
Yep,
yeah, that's
I
fine.
like that.
All necessary requirements for open space are met. But because all lots are greater than required minimum,
Or just are met.
do that too.
Let's just do
Yeah,
that.
I would just say Armet. I agree with OJ and then just leave because off of that.
proposed streets are in harmony and conformance with existing streets.
Period.
Period, yep.
The plan does not impair corner visibility.
I take that off.
I think that's covered in number 12.
Yeah, okay,
I
take
mean,
it out. All streets will satisfy all town of Lincoln roadway standards.
I would say, if you want to say, well, you can say they must, instead of well,
These are findings of facts, we're gonna move on to conditions.
okay. I'm okay with that.
So all streets satisfy,
well, he says, all will satisfy. What if you just said, all streets will satisfy?
all streets will satisfy all town of Lincoln roadway standards.
Okay.
The application provides for adequate fire protection. I mean, that's gonna be a condition of approval, so
Right.
we need to put it here.
Yeah.
Jim, can we just say there that the application has been reviewed and approved by the Lincoln Fire Chief?
He hasn't approved it yet. Still,
I thought, my understanding was that and if Ron's there, we should ask him. I thought he did.
you're shaking your head no, right? You haven't reviewed or approved it. In the review, so we won't find it. Done it. So we'll make it we'll make that a condition of approval rather
Oh, okay.
than finding
I
a
thought,
fact.
I thought after all the meetings we've been through, when we talked to Ron to look at it, that by now he
I mean,
should have had an answer for that.
he's indicating he's still going back and forth.
Can we say the application will be reviewed and approved?
Yeah,
Well,
that's fine. We could put that in, Jim's right, as a condition, I suppose.
I would just put it as a condition.
Okay, all right, that's fine.
So this one's a no, and we'll put it in as condition.
Yep.
I think I have it on my conditions thing anyway, yep.
Sidewalks are not required to substantially serve pedestrian safety.
I would take that out.
I would take it out. Anyone else is good with that?
You get it.
Land is not of such a character to create a danger to health. Just take that out.
I'll take that out.
Land is not of such a character to create a danger of flood.
Hmm.
Take that out. We haven't really discussed it. Discussed
Well, we've
drainage.
discussed the issue of flooding, I think,
Yeah,
pretty extensively. I would like to reword that the land is, the development on the land,
I would say the development will not create a danger of flood.
an increased danger of flood.
That would work.
Land is not of such a character to create a danger of fire.
I think I would take that out.
Yeah, I would take it out.
Yeah, because Lincoln did burn down twice already. Yeah.
20 is kind of repetition of what we just discussed. I would take that out.
I agree, I, that's in there, but
21, I think is relatively redundant too.
Yep.
No natural drainage way will be obstructed.
But it has been addressed by the plans,
Yeah,
by engineers.
I would maybe just leave that one as is.
Yep.
You okay with that, Joe?
Yeah, next one, we talk to that too.
Yeah, so 23 we can take out.
22 should actually be a note on the plan. I mean, I don't see why it needs to be a finding of fact, but I would think 22 would just be a note on the plan.
We already, did you put that on the plan?
Maybe the applicant knows. Is there a note on the plan that deals with this?
I didn't see it, but
No, none of that exact note is on the plan, but obviously it's talking about like some natural
Yeah.
drainage ways, just the wetlands, and as we talk about protecting the wetlands, so. And then we're not going anywhere near that stream that's on the other
Yeah.
part of the site, so there's really no note to add, I mean. For our design and the review, we're not impacting the natural world.
Well, it's just, to me, it's a point that should be on the plans that whoever's doing the construction sees it and knows it.
No, you can make that condition, we can add that to the plan, like, yep.
They're subject to the no disturbance easement, which is shown on the plan.
I was gonna say, that's gonna be on.
Yeah.
Was that? Yeah.
Out of the order conditions and the alteration of terrain, we'll have that, yes.
I mean, does anyone disagree that no natural drainage way will be obstructed?
No, I just leave it like it is.
You okay with that, Paul?
I'm fine.
Joe? 23 taken out. Adequate drainage and erosion control measures have been or will be taken as a condition of the subdivision approval. I would take, have been taken.
There's noted on the plan.
As noted on the plan.
Yeah.
I would just say have been. Because they have been in accordance with the Stormwater Management Act.
Have been taken. I'll leave it at that.
Yeah.
Yeah.
Take out the or will be.
Okay. Okay. The application does not present an appreciable impact on traffic congestion or traffic safety. Put that as period.
Yeah, so at the end of traffic safety, you just put a period in, took out the rest, right? Period. No, I'm sorry. I thought there was something else. I'm gonna turn my lights on.
And 26, I would take that out because, if they get approval, compliance with the technical review memos would be conditioned.
You think you want to take 26 out, Jim? Is that what I heard?
Yeah, I would just, that's gonna be a condition of approval. They haven't met the, they haven't addressed all the concerns just yet.
Okay.
I don't want to make it a finding of fact. Right, we have technical memo number 3 that hasn't been addressed yet.
Right.
Now that you've run through them, can I just ask for a clarification? So for the record, when people are looking at this later, what happened? For each of the items that you guys have removed or taken out of the list, I understand that to mean that the issue is not an issue brought up or a concern. Didn't need to be addressed because it was not a problem. Or that there's going to be a condition imposed that addresses whatever issue was raised in one that was strange. Is that the right takeaway from what you mean when you removed it from the list?
I mean, once we scratched out, they're not part of our findings of fact. But some of them might be included in the conditions.
I understand, but the reason you're not making findings of fact, so I'm clear, is because they're not a concern to you. Like,
Some of these have already been addressed.
okay, just so I'm aware that means your satisfaction, it's been addressed in one way, shape, or form. It's not a concern. That's what I took away. Is that right?
This has been
Yeah.
beat to death, yeah.
Yeah, that would be my
Yeah, okay. Thank you.
understanding of my reasoning behind that.
Thank you very much.
Ready to move on to potential
Jim?
conditions. Paul?
Could we put Mr. Licks, make sure that his question and the responses is part of something so that we have something memorialized of what we're all agreeing to here?
I would love for that comment and response to be put in the minutes.
Yeah.
Thank you.
Yeah, I just want to make sure that we're all doing the same thing here.
So this one I have conditions so far. Subject to review of HOA docs to include ownership of the stormwater management systems. wetlands protections in the deeds. Review of access for emergency purposes by the fire chief. Then a performance bond, scope, amount to be negotiated between the town engineer, the applicant's engineer, and their attorneys, and their respective attorneys.
Jim?
Paul, yeah,
Yeah, could we have the Board of Selectmen look at this bond issue as well? I just want to make sure that they feel that they're protected as well and that they weigh in on it. I mean, it's a town after all, it's gonna have to come up with the money if the bond is not right, so. I don't know OJ's there, but I would feel more comfortable if the Board of Selectmen looked at it and said, yeah, we agree with this.
I mean, I think that I'm gonna listen to what Ray says. You know, the engineers are gonna work this out, and if Ray comes back and says, look, you get screwed, then I'm gonna vote against it. Whether it's on the select board. I mean, I don't have enough expertise, and I don't believe either of my selected counterparts do that. We're gonna rely on really the town engineer, and I'm sure Jason will look at it, so it's really gonna be a administrative
All right,
review of the two experts. And I think the
Fine.
planning could take their opinion just as well as the selectmen can.
okay.
then review of plans for compliance with technical memorandums 1, 2, and 3.
You just change that to 3, 1, and 2 been addressed. So we just at 3 now. That they kind of
Okay,
cumulative, right? So there's no reason to go back to 1 and 2.
is everyone all right with that?
I 1 and 2. Ray's okay with 1 and 2. We're sure of that.
So yeah, 2 was a response to 1, 3 is a response to 2, common responses and revisions. So it's like 3's where we're at.
Okay,
Subject to obtaining necessary state and federal permits, if any. No parking on public roads during construction. Catch basin on Mansion Hill Drive.
Relocation of the drainage, if Ray and Nate approve, is gonna be one of the conditions.
Right. that's what I'm talking about.
Drainage outlet from basin 1 being connected to the stormwater system in Mansion Hill Drive.
Subject to review of the Public Works Director and the town engineer. The submission of the stormwater inspection plan and appropriate reporting to the town. That's all that I have.
Jim?
Yeah.
How about the legal language for that protects wetlands areas?
So
And
I put wetland protections noted in the deeds.
In the deeds.
indeed, okay,
The review, subject to review of the HOA documents.
okay. So you did
So-
something, you included something in there about HOA documents?
Yes.
Yeah.
The HOA documents are to include ownership of the stormwater management components.
And the HOA documents also detail the infrastructure upkeep and maintenance.
Yeah.
The only other thing that I had, was that a commitment, and we had talked about this and earlier, was that whether or not the developer was willing to commit to not cutting trees down on the lots until they're ready to be developed. I know we had talked about that. I don't know where it finally ended up. I think it would be important to especially if this is gonna be a phased or a,
You know, they
Take-
will need to cut some trees to put the driveways in perhaps.
no,
Or
I
maybe-
mean, I understand that. I understand some of that, to do the roads and stuff like that. I'm just,
You talk about prior to any house construction or land use. permit.
yeah, I guess I just thought that if they went in and cleared the whole thing, that it would probably not be very nice to the to abutters and stuff like that. If they did it as they went, kind of, sorta, it certainly would, look a lot better and be a lot more palatable to people in the area. So that
I
was
think
my,
that's reasonable.
Because they did, something happened, God forbid, we'd be stuck with just a bunch of lots all cleared. And all you're any. This way, if you do a couple of you go, as you need be, you still get some vegetation and growth, something doesn't happen. The backup plan.
would the applicant be amenable to that?
Yeah, I don't think, he will certainly take it into consideration, be as careful as possible, but.
I'm sorry, I,
He's taken it into consideration. He hasn't said yes, but I mean,
oh, okay.
One manage that too, I don't even know how to. Additionally, construction vehicles going in, skidders, things
I
like
think-
that, we're gonna do maybe 2 or 3 times. We're certainly not gonna do all the lots at once. But few patches of them versus doing them one at a time. It's like we're gonna build a house and then all this equipment comes back in, it all gets hauled out.
I think Paul's concern is he doesn't want to see the whole site clear cut and then nothing gets built upon it. Nothing gets built upon it for a number of years.
I don't know why you couldn't just do the roads and the infrastructure below the roads, and then do house lots as they are either sold or.
Yeah, I mean, we may need to fill, there's cut and fill for certain lots and areas where I don't wanna. Haul it, fill up, free and out of here versus where. Take it out of a lot, add it to it. Procedure, site.
There's like this cross grading, correct, but between lots, so you can't just cut one lot and then make the grading work. You have to cut the other lot to make the grade work. It ties together. As you notice, there's grade lines that go across property lines.
I mean, you have,
Well, I don't know, you can only disturb a certain amount of the lot anyway, so that kind of goes away. That theory goes away. I mean, you can only disturb a certain amount of lot, or you're gonna get into some other problems, so.
Correct, what I'm saying is you can't just cut one lot because then the grading won't work with the adjacent lot. So if you say you're just gonna cut one lot at a time,
It makes
then you may have to cut the other lot to make the grading work and make sure the stormwater is going to where it needs to go to the basin that you already constructed.
Additionally,
I understand if they're common
Wait,
lots,
Paul,
but
wait, Paul.
putting all the stormwater and whatnot in place, I can't ask contractor. Take a storm bomb at the moment. Almost not fair, it's impossible.
Now, isn't it though part of the Stormwater Management Act that in doing that construction, that you have to secure the lot from erosion damage?
Correct. Yes.
So, I guess, doesn't that incentivize you to not like cut the whole thing? Cause then now you're gonna be planting grass and baling hay and
So, yeah, if you cut.
silk fencing.
Certainly, as I mentioned, talked about this more than once, our intent was to disturb as little as possible. In fact, that's why we're making the roads as small as possible. It shows the vegetation on the planet. We're doing, these aren't gonna be massive green lawns, it's not the look. Minimal disturbance, and we treat as much as possible. We're on the same page there, but to help to bring equipment in and out every time we lot is, especially with project bill and doing stormwater systems and utilities. Huge problem.
So as you mentioned, OJ, as you clear cut, or you cut any of the lots, again, you gotta put the erosion control in. Now it's the responsibility of the contractor to maintain all those erosion controls. So there's, that protection is in place for when you clear lots.
Plus on top of that, probably using a lamp, fill from one lot. Fill up on the other one.
Correct.
Can't do that for all. Separately.
Correct. That's what I was talking about when you talk about big grading cross lots. So you can't just do one lot at a time. 'Cause again, you need, one lot, maybe a cut lot, and the other one's a fill lot. You need that material to build a lot. So it's impossible to develop that way. So I mean, obviously, he's not gonna clear all 25 lots at one time, but you can't expect him to only do 2 at a time. It's not practical.
But again, I'm pointing back, I truly feel like. Maybe it's disturbances.
So Jim. I think maybe this goes into what Ray was talking about the methodology of how the construction is going to happen. And that's a note that should be placed on a note that should be placed on the plans. It's done in South Peak. If you take a look at their plans, there's a construction methodology. And, maybe at a minimum, they could do that. And some of that would indicate how many they're gonna do at a time. I don't know. Just something so that's not all got.
So again, yes, that's Ray's that's note 8, right? It's comment 8 on the latest technical review. Dated.
I think so, yeah.
Right, it's number 8. So again, that's what that's referring to, is the idea that you make sure that you're putting the proper, erosion controls in place, and that your storm management facility is built out properly. So therefore, during construction, you're not impacting the residents with stormwater runoff. So that's the whole purpose of that, is to make sure that you have a sequencing. That you're not just, again, clear cutting and then you just walk away, you just clear cut, and you're not doing anything else. So you start installing the road and you still haven't put the basin in or the stormwater in. So then that's the purpose of that note that would be added to the plans.
So Paul, I don't know, I know I read this, but you don't have it in writing, but they're gonna add to their plan a note that says the owner shall provide a construction sequencing plan to the town of Lincoln prior to the issuing of a land use permit. So,
Yeah, I remember that, yeah. I mean, I think that's all right, but I guess I would look at that comment from Ray, and when the applicant provides it, I'd just like some consideration to be given to how much of the development is going to be cut at any one time.
That would be noted in that sequencing. That would be part of the sequencing.
Yeah.
Be cutting the road and X lots 1 through whatever. I mean, that would be part that labeled out in the sequencing. Ray was actually, and Ray was asking about us to provide a sequencing plan for approval. Explain to him again that it's possible because you don't know where we're going to start yet and so forth. So then we added this stuff.
so let me ask this, when you develop your sequencing plan and you submit it to the town of Lincoln, I assume that's going to Carol. Can you copy Jim on it? Or maybe you can ask Carol to forward it to you, and disseminate it to the board.
Yeah.
So it would be sent to Ray and Carol.
Ray and Carol. All right,
Pass it on.
all right.
I'm fine with that, OJ. I'm fine with that being done.
Okay, does anyone have anything else?
Nope.
And again, just to clarify the record, these are conditions subsequent. We get a conditional approval. This is all the technical stuff, Ray and me and Jason and I work with all. That's what's intended technically.
Yeah.
Okay, thank you. Yeah,
These will be handled administratively.
thank you.
We talked about some specific conditions related to technical review 3, like show an easement on lot 7 to accommodate the installation of maintenance of level spreader on lot 6. I would think that that's gonna all be covered by that one condition of the meeting all of the technical review memo number 3 with Ray's approval. It covers, like, there's several here that I just read one, but there's several. That covers all of them. We good with that?
Yeah.
I just don't see any need in listing each one of these out.
No.
When we refer to this whole thing.
This is incorporated by reference.
Right, okay.
All right, so what's the pleasure of the board? Are we ready to vote?
Jim?
Yes.
So if we vote, we're gonna vote on the approval. That's what you're saying, right? Approval or disapproval? Accept? So. I mean, I just want to make sure that once this is done one way, if this is done and we approve this, I just want to make sure that, you know, we've been through a long process here. And I want to make sure that Ray gets to the applicant in a timely manner. And if Ray can't do it, then we need to find somebody that can. I mean, it's been a long process, and these people should have get approved. Deserve to have that done in an appropriate time frame. And I just want to make sure that that's done. If there's any way we can do that.
If they have an issue, they can go to the town manager and discuss it.
Town managers really, and Karina's here, but I mean, the planning board needs to be aware of these things. If someone that the board hires to do review plans is unable to get them for one reason or the other, or to get information back one way or the other, the board needs to be informed. I mean, I don't think it's appropriate that this happens.
Hey, I agree with you there.
You know, I mean, I just want it either in minutes or documented somewhere that, you know, should this get approved, that it's not going to take forever and a day for all the rest of this information to get back to these people as well.
I guess the applicant's free to come back to the board if they have some concerns. Yeah,
Sorry.
get the administrative conditions taken care of.
I just want to thank you for mentioning that. I appreciate acknowledging. And again, I think Ray is a fine engineer. I'm concerned that he may be a bit overwhelmed because a lot of things are happening in town. Could be the medical issues and all that, but I appreciate the comment, and I hope the town takes that in the spirit it's intended, which is, it's not that we're asking not to be reviewed and go through the first steps. It's just that we're asking that it be done in a timely fashion. And I thank you for commenting, and I'm sure the town administrator, Rena, right?
Rena.
She's here, she's listening, and I think that I think some folks have reached out to her and she's aware of it. I think it may be being addressed. So thank you.
I will echo that. Yes, it is being addressed. And I think this particular project was affected by medical issues that Ray had and has been tied up. And that's why he's not here tonight. That's why he was been restricted. Sort of a little bit missing. But hopefully that's a temporary thing. But overall, we are addressing that.
Appreciate it.
Ready to vote? Go.
Deliver, we should just continue the next meeting,
I'll say yes. I think we're ready to make a vote.
I'll go along with voting.
Okay.
Yeah, I guess I trust Ray and Jason to finish up the outstanding conditions. And I don't think there's any facts that are gonna come forward between now and 2 weeks.
2 weeks, yeah. Steve?
So Jim. My comment would be that I'm okay with voting. I still have a concern that that conditions subsequent should probably be addressed on the on the stormwater management and the square footage of the lot. Should Jason not be of the same opinion, it's gonna have to come back to the board because it will change the lot requirements. So, I mean, how do we do that? Then I guess I would ask.
Well, if they had to come back, we'd have to renotice all the abutters.
Right, and if we have another meeting, we can ask Jason, we don't have to re-notify, we just continue it to one more meeting, which we have time to do. And like I said, we went through the conditions, we went through the other things that Jason wanted us to go through. But I think this is an important question to be asked, because if it does come out that we failed or we erred when we spoke, if we did, then it could change the amount of lots that are available for development. And I think we need to know that. Don't you? Prior to an approval.
So I guess if three of you want to continue it for another hearing,
That's, well, gonna get the conditional approval, just that the items that have to be cleared up.
Yep.
I can go with that. We keep discussing the dead horse over and over. For hours, and we've already discussed it several times, more than several times. Just like Paul, like you were saying, about the stormwater management, the other things between Jason and Ray and engineers.
okay. Yeah, I think we're ready to take a vote myself. I will agree. Steve,
I would like Ray and Jason to smooth me over a little bit.
We can have Ray additional on it.
And this is pretty serious stuff. I'm not gonna go jump into it right now.
okay. So I guess from the full board, I'll start with myself. I'll say, yes, we're ready to vote. Joe,
Go with you.
okay, yes.
I'm
Paul,
No.
okay, so we're ready to take a vote. So let's vote on the findings of fact. There's a motion to accept the findings of fact
As
as
discussed
discussed and as amended.
and amended.
I'll make that motion.
I'll second that motion.
All right, all in favor?
Aye.
Aye.
I,
You voted no?
I think he said aye.
I think he
You
said.
said aye?
Yeah.
Okay.
Well, you said yes, correct?
This would be a,
Paul, did you vote yes on the findings of fact?
yes, I did. I made the motion.
Okay, well, it doesn't mean you have to vote yes on it.
be attached to
Yeah, this
for
will
the
be,
attorney's request.
yeah, this will be included in the minutes. All right. Should I read the conditions of approval one more time?
Yeah, let's go down through those. I have them all written, I think.
Subject to review of the HOA docs, which shall include ownership of the stormwater management members.
Can I just clarify that? The way I drafted the documents, the improvements sit on somebody else's property, but the HOA has an easement right of access, construction and maintenance. So depending on how you read that, that's not technically owning the property, it's just having. I would say that the HOA has easement rights to allow them to construct, maintain and repair those improvements, if that's acceptable.
So prepare. Subject to review of the HOA docs to include easements and ownership, of the stormwater management infrastructure.
Not ownership, easement. Rights to construct, maintain, and repair. Again, it's okay.
Read it one more time. Prepare review of, require review of homeowner HOA documents to include easements for construction, maintenance and repair, stormwater management improvements. Does that sound good?
Do you want the words easement rights in there? We know
Either way is fine, as long as they. As long as Jason and I know that we're reviewing it so that the association has those rights so they can do what you guys want to do.
Okay,
So,
so what you read is fine.
okay,
And then wetlands protections in the deeds.
Yep.
Review of access for emergency purposes by the fire chief.
Yep.
Performance bond, the scope and amounts to be negotiated between the town engineer, the applicant engineer, and their attorneys. Review plans for conformity with technical memorandum number 3. All state and federal permits, that's already in technical memorandum number 3. No parking on public roads during construction.
Get a question now.
Yeah.
No parking on the road, construction up there. What about the rest of the town? You do it to one, you do it to everybody, correct?
I mean, we don't set precedent. Every application is different.
Okay, so maybe I'll do a city president.
Yeah.
If they work over here, they can be parking along the town road.
Yeah.
And state highway.
I mean, whether we require it or not, they still have to, follow the state and local requirements for parking.
So I wanted to know.
Okay. Let's see, catch basin resolved. Catch basin a lot 1. That's what I searched.
Just basin, not catch basin.
Okay. I'm sorry, I didn't get, what did you call it?
Just basin or infiltration
Basin.
basin, not catch basin. You just say
Basin,
basin.
okay.
Yeah, or stormwater basin. Do you wanna call it
Stormwater
that?
basin. Into the town system, subject to review by the town engineer and Department of Public Works. And then a stormwater inspection manual and reporting to the town of Lincoln.
Stormwater operation and maintenance manual.
Stormwater operation manual and reporting to the town of Lincoln.
Or approval. You not only have to submit it, it has to be approved by Ray.
So he's
So-
seen that as
so-
part, so I just go, so as part of our latest submission back on 4/8, we provided the plans, drainage report revision, and which include the operation and maintenance manual. So all that has been reviewed by him and he had no comments in his latest technical review memo. So it's been reviewed.
Okay.
can I circle us back to number 8, just to be clear? My understanding on number 8, dealing with the basin, because that condition essentially means that the applicant agrees to connect basin number 1 to the town system if the town requests, it, and the town is trying to decide whether to request. Is that what we're saying?
Well, I think it's been, the board has requested that that basin be tied into the town's drainage system if possible.
Okay, so who's making that final?
It's the town engineer and the Department of Public Works.
So
Right.
it told, basically condition 8 is if requested by town engineer and DPW applicant is to connect. Done.
Well, if you're
that-
able, if the board is requesting you to do so, but only if you're able to.
As determined by the town.
That's determined by.
Gotcha, thank you, that's helpful, appreciate it.
So, subject review of this, so the stormwater operations manual and reporting. That's subject to approval by the town engineers that already been approved. Maybe we should just leave it in there.
Already been approved, you're just requiring that the applicant that we follow, in the HOA follow that and report to the town, those logs, that's what you're putting in there as a condition.
So the stormwater operations manual as approved by the town engineer. To be followed and annual reporting. See one?
Question.
think if you just word it, approved by Ray or whatever, and where we. The end result would be approved. Not to say it's already approved, because it may be.
It may be tweaked.
Maybe tweaked.
All right, correct, yes.
Just so that we're not closing the book on it now.
Okay. So stormwater operations manual to be approved by the town engineer in annual reporting.
Yeah, they could be tweaks that based on, the addressing.
We don't want you to go say, hey, we're not gonna make any changes because the board already.
But same thing as technical would revise those calcs if necessary, plans and rate review it.
Does the stormwater manual, are you aware if the stormwater manual has a winter conditions?
It does.
section? It does?
Yes.
Okay, thank you.
Does anyone have anything else? Is there a motion to approve the subdivision with the conditions noted?
Approved.
Is there a second?
I'll second.
All in favor, say aye. Aye. Opposed?
No, I'm an aye.
Oh, okay.
I'm an A.
All right, so 4 ayes and 1 nay. Great. Great, good luck.
Thank you.
Take an extra hour sleep in the morning.
You know, I know this is a long and somewhat painful process. We don't want to go through it again, neither do we. But I think that this plan is better, much better than what you came in. My biggest fear for this whole thing has been the stormwater runoff. And the idea of having separate homeowners associations and individual lot owners be responsible for things. I just could not see that working, and I think this is a much more practical solution to that, as well as changing some of the lots, reducing the size, you know, some of these other changes that you made. So I know it's long and painful, but I think it's a much improved product.
Thank you. Great. Thank you for your time.
Yeah, thanks.
Anytime you want to stay up late, come on back.
Yeah.
The free pizza.
We take two.
Let's take a 5-minute break.
Jim, if I can
Yes.
real quick, just because I have to get off and I know that you're most likely addressing South Peak afterwards. Is that correct?
Yeah, so I'm gonna do South Peak. So
Okay.
you need to get off now?
Well, relatively soon. Yeah, I mean, I'm kind of 2 hours past the point I wanted to be, but I just wanted to let you know that I know that you haven't seen Ray's email because it was sent late this afternoon, but all the administrative checklist is complete as far as what is due in-house to deem the application complete. And Ray
Okay.
does have some technical issues that he needs to address, but he doesn't think it's anything that should hold up the application being deemed complete, as it will be vetted throughout the subdivision approval process.
Okay,
That's all I
all
have.
right, that's fine. All right,
Thank you, Karina.
yeah.
Yep,
thank
no
you.
problem. Thank you.
Are you getting off now?
I am, unless
Okay,
there's
so I mean,
something.
if you're getting off, I'm gonna just do the 2 conceptuals real quick, I think.
Okay, yeah, that's fine. I'm getting off now. I mean, other than Scott, who might curse me for saying that's fine.
Okay,
Okay.
all right, thank you.
All right, thank you.
Jim, I was informed by Karen.
Right. mhm.
But I don't know if I can't get back that 3 hours of my life. If you have another South Mountain thing that's gonna take 3 hours.
Well, I'm just telling Karina, I have 2 conceptuals. I was gonna go through those real quick.
Okay, that's why I was gonna check.
Yeah.
If you have a South Mountain thing, then I have to pick another day to come back. So,
Okay, yeah,
okay.
you're welcome.
Yeah, it's got to midnight already.
I think it's time to get out of the lake, go fishing.
There's no time for that, Joe.
Oh, come on.
Too much to do.
One part of biting, so. One part of biting. Catfish. Biting.
Yeah. You're a fun fish or catfish since I was a kid.
You better eat than trout. The pain in the butt to clean it though.
It's a pain in the butt to clean both fish. It's a little bit more. You think catfish is better than trout, huh?
Well, it's probably catching around here now it's all fed with pellets, and they couldn't even get to the river. The airdrop different. A few places left in the airdrop, and I'm not telling anybody where they are. They have a nice pink meat to them instead of the great white stuff you get out of the river now.
Some of the rainbow stuff is pretty good out of the river still.
They've only been there a couple of years. Couple of years fast, put the fish stocks, put them in, people take them out. Some survive for 2 or 3 years beyond that, wide one.
So why don't we jump back to the two small conceptuals? Just one. Herman Foodie and Kelly Foodie, owners of Black Mountain Burger at Depot Shopping Center and La Vista Italian Cuisine Restaurant at Riverwalk Grand Hotel at Loon Mountain Resort, and Realtor at Remax in the Mountains. Looking to purchase 264 Main Street and convert that into apartments.
Correct, that's a 4,000 square
You
foot.
want to come up and speak in the microphone?
So currently, there's a 4,000 square foot space in the depot that might become available that I'm currently in talks with. And it is a difficult space to work with. And my idea is to convert it into residential. As we all know, we need more housing around here. I mean, everything's about housing, especially for staff, for the restaurants, everything. So I have a plan drawn up for 4 2-bedroom apartments in that space.
Okay.
Carol and Lisa raised the question if there would be a parking issue, but according to the town handbook, there's currently adequate parking as it exists right now without changing anything. We would actually require less parking than is allocated for the commercial space that currently exists. I would have to do fire suppression upstairs, but I've got a quote on that. That's not a problem. The Depot Association itself would have to pass the change of
Right,
use.
those are my questions. That's already been in the condo docs as commercial space.
Yes, we can change that. The people who are in agreement with that, I have enough votes to get things changed on site. We don't have to go to the state for anything, which is great. It's pretty much between there and the town.
Double sheetrock,
Double sheetrock if I don't have suppression. I don't have.
I think I take back why it was. Even with it.
Separate the two uses. What's underneath it?
There is a little bit of commercial space under both ends of that space right now.
Help build it.
As the apartments above the existing were designed to be apartments.
Right.
But the storage area was designed to have fire separation that residential requires.
Right, so it sounds like he's sprinkling it to get around that requirement.
Units upstairs are never gonna be residential. It was an office space. Help build it.
This is office space. He's talking about converting it to.
Okay,
This is upstairs.
But I'm saying, when I went ask Ron, you have to do double H5 with sheetrock, the rooms, with fire suppression.
Do the sprinkler system that the code allows. That's.
I'm just want to find out.
If it was a sprinkler, then it would have to go. It's a 5/8 height X. With fire stopping, everything, the whole thing, but he's probably going with a 13 feet system.
It's a 13. Yeah, so I want to talk to you about that at some point, but the bottom line is we're going to meet the codes required. So we can discuss what it actually needs. I've had a fire suppression company already there. They seem to be very familiar with what the rules require. I'm going to get it done right. I just want to make sure that we don't have a problem with the town and what we're doing. So that's up to you guys.
It's required for the water fill point, that's about it.
Say what, Joe, sir?
You require water fill points, that's about it.
I think we have that. We do need to check the amount of water coming in and pressure. There's a couple other things, but
Not that, the amount they set you per apartment. You have to have so much for a sink.
Right. You're increasing the water.
bathroom, toilet.
Right,
showers.
that's why we have to check the water pressure and we have to make sure that we have enough water coming in.
Hey, Jim?
Hold on, everyone can't talk at once.
So when you say impact means you basically mean the costs associated with adding those. Yeah, not a problem.
Will you be having a need for a second means of egress from each apartment?
So the way my architect has it designed currently, we have a back entrance and a front entrance. And he's able to, again, going by the rules that we need, we can do 2 apartments with 1 access point and the other 2 apartments with an access point. And we stay within whatever the requirements are that we need for that. So we're not gonna have like a hallway connecting all 4 apartments. There'd be 2 that has a front access and 2 that have a back access.
Plus, another thing, you have a pretty much flat roof on one side, which is, can be used as another access point, am I correct? On the pitch roof in front of Moon Res. You're coming up, that slope roof coming up, you can walk on it pretty easy, that could close it.
That all.
Okay,
But it doesn't sound like I need 2 access points with just 2 apartments. From what the architect's telling me, we don't need a second means of egress because we have whatever big hallway going up and there's 2 apartments, so I
Well,
might be
you'd have
wrong
to-
on that.
in your case, you climb out the window, you're almost down to the ground,
Yep, I would imagine that be a bit of a fall.
and then 6 feet, it's up feet, okay.
Yeah, I think the bottom line again is if there are any code issues, I'll either meet them or exceed them. We will be where we need to be. I just want to make sure that we don't have a problem with doing a conversion from commercial to residential. And as Carol and Lisa mentioned, their concern was the parking, and I think the parking is not an issue.
The downstairs is sprinkled, isn't it? I believe,
The downstairs commercial,
yeah,
it is not.
would that be sprinkled or different code for going up to 5 to the second floor?
It's applications.
But the rest of the building underneath it is not sprinkled, he said. Well, you thought of what?
It is not.
It's wired.
Okay,
There might be sprinklers in the hallway. I'm not sure, but there isn't in the units. I know that.
but there were some places that were sprinkled on the building rebuilt.
It could be the 2 big hallways possibly. Yeah, that hallway. I'm sorry, the entrance, whatever. Yeah, that would be the spots. Stairwell.
I'm not trying to get that, it's what you know, the property you go into, you're not surprised at the end. Stop.
Well, I don't think I'm surprised right now.
Yeah.
There's some costs associated with doing this, but in the long run, it gives us extra housing and we desperately need that. Not just the business, but I've got applications for people who want to come to town, and one of the first things they ask me is, who do I go see about an apartment? I'm like, yeah, I'll give you a couple people, but good luck.
Paul, you had a question?
Yeah, I did. I kind of missed the parking thing. Herman talked about it, but
Carol had a question if we had a sufficient parking. Per the rules that exist in the handbook that you guys have here, I don't remember what it's called. There's an allocation of 1 parking spot per every 400 square feet of commercial space, which means there's 10 parking spots allocated for that. I believe the 2-bedroom requirements are 1.5 parking spots. Thus, it would be 6 parking spots we would require, and we already have 10 as far as commercial space goes.
okay. All right.
Yep, we'd have to check that.
Yeah, probably should. The only other, I had 2 questions on this. So Herman, I heard you talk about an architect, so you will have a stamped set of plans from an architect for this
Yes.
renovation?
Yep.
Okay, because the architect will know all the codes and he'll be
Yep.
able to design to that. The other question I have is probably more for OJ in regards to water and sewer availability for something like this. Does that have to come before the town?
Is that a question for me or for OJ?
It's probably for OJ because we discuss this every time, Herman. I think whenever there's I don't know what the capacity is of the town is, and we keep adding stuff to it, and it's.
Well, I
supposed to
will
happen.
say, if not to interrupt you, I'm sorry, but there are 2 or 3 bathrooms up there right now. And we are only, with the 2 bedrooms, they are gonna be all 1 bathroom units. So I think it would be an addition of 1 bathroom currently. I gotta check. I believe there's 3 up there right now.
Well, you'll have sinks and faucets. I'm assuming they're all gonna have kitchens in them and stuff.
Yes.
Yeah.
Yeah, but there's also a kitchen up there right now too.
Yeah, no,
There's-
I'm just asking, because every time somebody comes in, it just adds more and adds more, so that's what I was
No,
asking.
I fully get that. I'm just saying that there is some there, so we're not like we're starting from scratch. There will be additional fixtures, but there is some existing, that's all.
Yeah, we're not within 4 units of a stoppage of development in this town yet.
All right, nope, that's fine. I just know that every little bit brings us that much closer, so.
Okay, does anyone have anything else?
We need housing.
We need housing. We need
There's no
housing.
doubt about it.
I think we all agree on that.
Yep.
No question.
Go for it.
Okay,
Great.
so my next step is to bring a plan
Yeah.
to you guys at some point, right?
Application for site plan review.
Yeah, okay, good enough. So I'm good for now.
I mean, we agree with the concept enough to go forward, I guess.
Great. Thank you very much. Appreciate your time tonight.
Yeah. All right. So, yeah, just CC.
Got his bodyguard too.
You're safe.
So I'm Roger Ruby. I work with Jesse. We want to just add an apartment to an existing building that already has apartments in it, and commercial space on the bottom.
Okay, so this is the old sport Toma.
Yep.
Okay, so how many apartments you adding?
We're just adding one to the front of the building. So a third of it is already covered. It just has high ceilings. We're gonna lower the ceiling to make the other side of an apartment. And add on.
Okay, so I think the only issue, do you have enough parking for all the apartments? That's the issue.
Oh, there's gotta be,
Oh, okay, okay.
yeah, they got the whole side of the building, must be 7 or 8 parking spots there, and then the back of the building.
Okay.
And right now, there's just
But-
2 apartments in there.
What,
Yeah, go ahead.
you're gonna keep part of it commercial. Cause you need, still need parking for the commercial part.
Yeah.
So with the commercial part, for parking, the apartment, you want to know if you have enough.
Right, you'd have to demonstrate you have enough parking off street for everything.
That would be me.
Sure.
Biggest thing. Yeah. I mean, there's parking on the street.
We
That's
don't,
not-
we can't count that, yeah,
Back, they may lose that parking. Next few years,
that's why we don't count it.
they say you take it away from.
So what was it, 1.5 spaces per apartment, and then
Will it be a 1 bedroom, 2 bedroom,
it's a 2-bedroom.
2 bedroom?
Yeah.
I think we need more than 1.5.
Two, I thought it was 2.
Yeah, I thought it was 2.
Okay.
But we can, both buildings, so we can just.
Yeah. I mean, he owns that whole area, so the back, we already made plans to clear off and make parking back there, which would add to both sides. I mean, I know it's not on the same property.
Well,
So you need to have an
the other guy's property, your back. You have to commit a special exception, it brought these.
Yeah, he would have to just
You
change
can't
that.
be saying park on my other property. It's not the same deed.
Yes.
His property though, does that matter?
If it's not,
If he sells it,
Today.
Yeah, yeah.
but if he
Might
sells
not
the
be his
property, it's not
property in
his
5
anymore.
years.
Yeah.
And then it goes down to 2, yes.
So the retail space that's there now takes up that whole front first floor
And it's selling basement.
Yeah,
and the basement?
Yep.
Oh, that's right. And so that's now gonna be half of it retained as retail?
nope, the whole that's still gonna be there. It just, when you go in, there's tall ceilings
Yeah,
on the right side of it.
okay.
So we're gonna lower that ceiling to normal and continue the other side all the way across to make the whole front of that apartment of the second floor.
So you're not reducing the retail space?
Nope.
No, that's
just-
Oh, okay, all right. I was
Retail space
confused.
will stay the same. It's just, we're lowering the ceiling.
Okay,
So the retail space staying the same.
Yep.
provide more parking.
Yeah. Yes, I think the biggest issue is ensuring you have enough parking.
Unless you get special release, from the owner beside you, you send me land for parking.
You'd have to talk to yourself about that,
Yeah.
parking on your other property.
Yeah, we can just do the parking, like I said.
Jim?
Yeah. I think Paul wants to say something.
Jim, the board has in the past allowed other properties to be used for parking. I know like the bagel shop, remember when Bill and Bob's, remember during those times that we have allowed that in the past. I don't know if that's something that could be allowed here where Jesse owns that, but it
I
may
mean,
be.
that's what we're saying. He can use his other property, but he has, have a proper easement in case he sells the other property.
All right.
Jason property, is that right?
Correct.
Okay.
Under the same name,
It's all, all in the same name, so.
not the same name, it's how you divide it up in lots and paper, the town maps. If you have 3 other lots of the store, house and back, one on the side, plus this one. It's 4 properties, they're not all connected together.
Yeah.
4 separate deeds. You sell one off, the other guy, you use his property, he can be short parking for his property.
Yep.
You know what I'm trying to say? Get figured out.
So the parking is
That's, yeah. I mean,
just gotta prove that there's enough parking.
I would say that is,
So like a 3 apartments, so how much parking we needed?
you have 3 apartments there already?
No,
No,
it's 2
and
apartments
this
in
will
now.
be including the 3rd, so we have got 2 apartment already there. Yeah,
So one more.
2 apartments already.
So that'd be 6 spaces.
Yeah.
Plus whatever the square footage is of the retail, is it 400?
I think it's 400 square feet,
For every,
plus 10% added to that employees.
okay, so for every 400 feet, 400 square feet of retail, you need 1 space. So you have to add up how much retail space you have, and then you add the 10% on for an employee space.
Last, each space is already over here on the side of the building. and
How
plus,
much commercial space is there? Is it about?
Probably the 2800.
Would
She
you say
needs-
2,800?
2700 or 27 or 2800 square feet.
So 4 times 7 is 28, and 10% on that
Approximately,
is 8,
Is 8, and then you'd need 6.
6
So you need 14 spaces.
off street.
6 for that.
Huh?
For the retail space, we need the 6 per space.
You need 8 for the retail and 6 for the apartments.
I think there's already 10 space like on the side of the building.
Yeah, we'll have to,
Yeah.
we'll have to check it.
Joe,
Few in it, they have to.
Yeah. One solution. They already
They said they were gonna do it when they.
retail space in the park. And the other 2 apartments. Up there. But then it's in the back, you can actually squeeze 2 more parking, 2 more additional parking places on the same property. Close to the boundary line, where the lot configured in the backside. You get the extra 2 places for another apartment. If you consider the other parking for the store, the other's already grandfathered.
well, no, he's coming in to do add, so he's, the whole site comes under site plan review.
So, okay, good.
He'd have to meet the current, I mean,
Apartment, you guys already end up with.
right. I mean, if he's short on spaces now, we can't force him to close, but if he comes in to expand. Yes, bring it up
I'm
to,
just trying to go for
yeah,
tonight.
I understand.
Our biggest thing will count.
Yeah, I think, I don't think anyone here is against you as long as you have enough pocket.
So what do we do now? Just,
So come in with come in with a site plan and have Carol review it. Just to make sure it's worth moving forward. Yeah,
I get one other,
go ahead. Yeah, sure.
you told me once about the barn behind your rep. You mean, remember the barn, but beside you back at the grocery store?
Yeah.
You had a barn back there that we belong, with, used to be up front, we put it out back.
Okay.
Talked me a little while back, about putting an apartment, residential apartment in that barn.
Yeah.
Put over bond, but you enough parking places now allowed to do it. You wonder if you could actually do that. Just trying to bring it up while you're here. We can discuss it, board, if there's no deal, but. The whole board, or just me telling you. Yeah. If you do it all one shot, we're doing it conceptual, just get it over with.
So.
Right where the triangle is on the back.
Yep.
The right of it, the back.
Yeah.
Which could be converted to two studios or one apartment, which beside the apartment.
Okay.
But you enough land in front of it, beside the store to put extra parking in. Same lot.
So I guess you could. You have to come up with a plan, but you know, if they're close, he could have an easement. For those parking spaces on the other land.
The other one. This is the the other piece here, the committee. But while it's here, for you to discuss it a little bit. You did ask one time, trying to get it in here. We feel the board out how we can probably do it.
But you know, we don't actually have any criteria how far the parking spaces have to be from the unit per se, but I mean, I think, you know, you'd have to be practical.
You'd have to get bring up the plot plan, look at it.
Yeah, but I mean, they'd have to be practical. I mean, you can't say I gotta walk 15 minutes from the parking space.
Parking place, you put here, that wall.
Yeah.
From the bottom.
Yeah.
Maybe 5-10 feet there.
Mhm.
And the parking spaces have to be a certain size.
Right. And by. They've reduced them a few times.
It goes up 15-20 feet going to the old Chinese restaurant too. We could bring the plot plan, put it on the map. Do the whole thing, as we draw it up with all one, probably is that one you want the comments. And probably the one on the other side. You get approved, doesn't mean you have to do it right now, if it's approved, you're already approved.
All right, we'll count parking spaces.
Yeah.
All right.
We're gonna do.
Very good, gentlemen.
Thank you. Thank you very much.
Thank you.
Thank
Good
you.
luck.
Yeah.
Thanks.
Yeah.
You are glad for not you. One trip, one trip.
Well, that's right. He bills them to travel, each of them separate to travel, right?
Right, but I get to split it between pockets. They're both.
I think we double up it. That's what I would do.
This is his show to.
Application for subdivision, Mark Bogosian.
All right, good evening.
Good evening.
So we are back, John Warzokin, with Horizons Engineering. The South Peak guys could not be here tonight, although Scott Michelli is on the,
Okay.
on remotely. So I guess where we left it last time is that you were looking for some feedback from Ray in order to do the completeness review. And it sounds like you have that feedback. Just to give you a quick update on where we stand, we have gotten two technical memorandums from Ray at this point that we have gone through and addressed and submitted responses to Ray. So we submitted a response, it might have been this week for his technical memorandum number 2. We've also submitted alteration terrain and wetlands permit applications. We've got RFMIs back from the state on both of those, and we have resubmitted the response to that for alteration of terrain and are currently working on the wells. So that's kind of where things stand today. So I think we're, as we talked last time, we're really just tonight looking for completeness determination. And if there's any other questions, I do have an updated set of plans here that reflect the most recent set sent to Ray. Obviously, these are in a state of flux because Ray has not completed his review yet. So I can hand these to you if you want to see them. Wasn't sure how the board would like to proceed on.
I mean, if you have copies, I wouldn't mind having.
Yeah, no, absolutely. I will apologize when I printed these. They're double-sided and the back pages are flipped upside down.
Okay.
So you're going to kind of have to rotate back. That's my bad. Our
They're gonna kill me.
our production person was
Thank you.
this week, so I have to do my own reproduction.
So that's gonna replace the one dated January 2nd.
That's correct. So that was the original submittal. This supersedes,
April 16th.
April 16th, all right.
yep, so this is hot off the presses, the latest and greatest. Again, I would anticipate it's probably gonna be, there's gonna be some continued modifications once we get further comments from Ray.
From my perspective, folks, I mean, this is just another continued next phase subdivision, sort of the same project, et cetera. From my legal perspective, on the easement side of things, I've already been in touch with Jason. He has already reviewed all of my easement language and said everything is fine. So the legal perspective side of things is done. And again, just so you know, the way this works is our view is has to be for easements a condition subsequent again. The process is that some of the easement language, et cetera, is put in the deck, put in the application that goes to the Attorney General's office. And the way this sequencing has to work is we need town approval, then I can do the easements, then those are submitted, the plans and the easements are submitted to the AG office for approval. That's sort of the next step. So that's the sequencing from our perspective. But Jason signed off on the concept and the actual language. It's just a matter of, we actually have to put it in the documents themselves at the right time. Deeds will have the easements and the deeds go out. The AG wants to see what the language is generally. Hope that makes sense.
Okay. Anyone have any questions at the moment?
I do.
Paul?
Yeah, so can I ask what has been addressed on a second set of plans? I can't see it. I guess I would ask, have the minimum lot sizes been addressed?
Yeah, I believe the lot sizes have been adjusted.
Okay.
And mostly it was stormwater. The frontage issue has been addressed
Right,
as
and there
well.
are a couple of landlocked.
Yep, and I will point out, and Derek, you can maybe confirm this, but I don't, just to be clear, I don't believe the minimum lot size applies to the master plan approved. So basically, this project, even though I believe we are complying with the minimum lot size, I do not think that applies to Southgate.
Right. Because the total units were determined by the total acreage dividing by 15,000 square feet.
But some of the units are bigger than 15,000 square feet, so.
That's correct. Yeah.
All right.
Yep. So, and Paul,
it does apply.
Well, I would just say it applies, but it's already been factored in by the master plan.
By the master plan. Can I ask how the green space plan is proceeding? Because of the one that was submitted showed the river as green space, and we talked about getting an updated plan for that.
yeah, so we don't have that tonight, but we understand that the town has, that you folks have asked for that updated open space plan, and we will plan on providing that. We're going to shoot for the next meeting to have that plan.
All right, when I look at the plan, what's the height of the bridge?
I believe it's 13.6, I think.
It's
Scott,
14.
14, okay, sorry.
It's 14 on the edges of the road, and it's like 16 in the center. And we had reviewed this with Ron Beard a while ago and got an email from him saying that it meets the minimum height that he needs for his equipment.
I'm fine with that. That's what I was going to ask. The 20 lots that are above the 1,000 foot level, it's not supposed to be in construction on anything above the 1,000 foot level. Even in Ray's review comments, he makes a comment about that. What's the applicant's thoughts about that?
Yeah, so Ray's comment letter requested that we put a note on the plan, and he gave us the exact verbiage that he wanted, and we put that on the plans, and it basically says, you know, there shall be no construction above 1,000 feet without additional written confirmation from the town, something like that to that wording.
Yeah, I mean, I looked at the plan on sheet 2.12 at number 18. I think you should read that that it should not commence until the water storage tank has been installed and is online, I think would be a that. I mean, I guess my question that as I look at that 1,000-foot elevation is, I personally don't have a problem with you doing the roads and that go up through there, but developing the lots might be an issue. However, when I say that, I also think about the fact that there's fire hydrants that are on that, going to be on that infrastructure that you're putting in, and they probably won't service anything. So I'm not sure it's probably appropriate to put fire hydrants on a water line that can't develop that kind of serviceability. I guess that's a question for which way you guys are headed with that. Do you have any comments on it? Are your plan is to just only go to the 1,000, or were you coming in to do? I thought the last time the committee were talking about doing the infrastructure, the road all the way up through, just not doing the lots. Is that still where?
Right. I think that is the intent. I think the intent is we got to get the road built, all the infrastructure in before any of the lots can be developed. So basically the road's got to be constructed. We know the tank is progressing on the town end. So it's understood that, nothing above 1,000 feet. Now we've asked for review of the water design that's kind of underway now, kind of trying to coordinate that with the town's water engineer, Weston Sampson. So we can offer what the flows and pressures would be in those hydrants under current condition. But yeah, I mean, we understood that those hydrants aren't going to be fully functional until that storage tank goes online.
Has the fire chief, Ron, I guess you're there, I can't see, but have you looked at the cul-de-sacs up in there, and are they sufficient for what you need?
I'm gonna have to review it, like, they're just completeness tonight, right?
Correct, just application.
Still gonna have work right on review. I think it's gonna be changes, but
I'm sorry, I did not hear that. Could someone repeat it for me?
He's gonna talk in the microphone.
that's yeah, I'm still gonna review this with Ray and everything. I haven't gone through it all yet, but
All right, so as far as the fire department review, that has not yet been complete.
that's correct.
All right, thank you.
Paul, I will note for the record that we did design the cul-de-sac radius to be even larger than the cul-de-sac radius that we did on Cedar Circle.
All right. And the only other things I have for this project were bonding. We had talked about bonding for this project. I don't know who handles that. I guess it's Ray again. But I'd certainly like to see some bonding going on. I think you guys have a lot of area going to be opened up, a lot of different phases of this planned phase development. And although I know you intend on doing it all, things happen, and sometimes it can't be built like it wants to be built or should have been built. So I think that there's a concern, at least in my mind, and I've seen it happen in the town of Lincoln, and I think that there should be some consideration given just in case this happens.
Paul, I think we're open to, a letter of credit or something in that effect. So we can work that out as we get closer to approval and understanding of timing. There's a couple different ways you can do bonds. So we're open to entertaining that.
That's fine. The other thing was, are you working? I know you are coming in for something with where the Pemmy Bay, the clubhouse and those 7 lots. Is there some way that you can address Pemmy Base Camp in that same application, and get closure to that? And And also, are you planning on fixing that area down by where the lift is, the new lift?
Well, that doesn't have anything to do with this application.
You can say that, but it does to me. I'd like to see things cleaned up before you move on. And you can say it doesn't apply to you, but when Mark Bogosian came in, he said he was gonna be, let me finish. When Mark Bogosian came in, he was gonna be the best thing Lincoln ever saw. And I've seen developers come and go. And all I want to say is, I'd like to see those things cleaned up.
And not disagreeing with you on that, Paul, but I guess my point was not meant to be snide, but this application doesn't have anything to do with Penny Base Camp in and of itself. We're looking, again.
You're 100% right. All I'm saying is, I think if you're gonna put your foot forward, make sure the foot that's behind you is all cleaned up.
Well, we are going to be presenting that application next week, and I think then we can talk about that. But
That's
our
fine.
next meeting. So
That's all the comments I have.
Anyone have anything else?
Glad to put the bridge up to 12 feet, if we put the other one in, it's over 7 foot. We can get under with an ambulance. We presented plans.
So why don't we open up some public comment, and then we'll go through the application. The motion?
Do we need to go through and make sure it's complete before we have open public comment?
They should have, they should comment on it first, just in case there's someone wants to argue that something's missing. I'm fine either way. We can accept it first. Let's go through the application. Yeah. I'm just gonna run through it. If anyone wants to stop me, just has any questions, let me know. Names and addresses of butters are required and provided. Application and notice fees and check payable to the town of Lincoln, required and provided. Preliminary layout or final plat is required for a particular application, required and provided. Site survey map, 4 copies of map at a scale not smaller than 1 inch to 100 feet. It should have the following. See, that's required and provided. Name of subdivision, required and provided. Name and address of owner, subdivider, required and provided. Survey and engineer, required and provided. Date, north arrow and scale, required and provided. Names and addresses of butters, required and provided. Report natural resources from natural resource inventory. Wetlands as defined by HIS map. Hydric soils, wetlands, overlay zones, etc. Required and provided. Building and setback lines to include setbacks from wetlands, required and provided. Land to be dedicated to public use, not applicable. Percentage of site, fields and in woods, required and provided. Property lines, existing buildings, historic sites and structures, required and provided. Existing streets with names or route designations, required and provided. Size of site in acres with number of acres in village residential district and in general use district, required and provided. Topographic contours of water courses, both seasonal and year-round, required and provided. Wells / municipal water sources within 150 yards of site, required and provided. Soils, required and provided. Town consulting engineering reimbursement fee, required and provided. Tax map changes fee, required and provided. All right, so site location map drawn at a larger scale and shown on the site survey, a proposed subdivision map with tax map page and parcel numbers, required and provided. Zoning classification, minimum lot size and frontage, required and provided. Size of site in acres, required and provided. Existing streets with names and route designations, required and provided. Additional subdivision information either shown on the plan or provided separately. Buildings remain not applicable. Deed restrictions, required and provided. Preliminary drainage plan, required and provided. Easements, required and provided. Future subdivision proposals on same site, not applicable. Lot lines, required and provided. Soils and groundwater test pits, not applicable. Proposed open space, not applicable. Percolation test location.
Whoa. Can you go back to the open space again?
Proposed open space.
I don't think that's not applicable. I think that is applicable. And I think they're going to provide an updated green space plan. So.
Okay. Yeah, we agree.
Okay.
We'll provide an updated open space plan.
Yeah, that's all.
Right, percolation, test locations, data not applicable. Approvals and comment federal, state, and local. Preliminary road cross sections and preliminary road profiles. Required and provided, setback lines required and provided. Proposed names / roads with locations named and right of way widths required and provided. Water mains and other utilities preliminary required and provided. EIS and or environment assessment to be required, not applicable. Overlays or special investigative studies to be required, not applicable. Applicants review section 5.02A of the subdivision regulations for official listing of map requirements. Final plat required for major and minor subdivisions. 3 paper copies of 1 mile and no smaller than 24 inches by 36 inches required and provided. All information described in preliminary layout except with the drainage, road plans, and profiles for water and other utilities shall be final, required, and provided. Name and address of all individual owners and or corporations of lands involved required and provided. Names and addresses of all abutters required and provided. Existing buildings, streets, right-of-way, streams, and easements required and provided. Natural features in the vicinity of the affected land required and provided. Name, address, and seal of surveyor or engineer required and provided. Small location map indicating parcels in relation to major streets and intersections. Tax sheet and parcel numbers and the zoning districts required and provided. Bearings and distances of entire property and lot lines based on an on-the-ground survey plus topography and 5-foot interviews required and provided. Lot areas and dimensions in square foot or acres required and provided. Lots numbered in accordance with town tax map policy required and provided. Statement of responsibility and liability for roads, streets, roads, and their maintenance are provided. Estimate of cost, required improvements, and statements concerning bond or other security are provided.
Is that?
Fair to say that those items will be provided
Yes,
once we get to,
once we get into this, and
Right.
yeah, yep.
and that includes the statement of responsibility.
Roads and maintenance. WSPCC subdivision approval not applicable. State driveway permit, if any, not applicable. Legal documents for homeowners association or other arrangements for property and utility management not applicable.
Excuse me. Could
Go
could you
ahead.
read that one- Could you read that one more time? I'm sorry.
Legal documents for homeowners association or other arrangements for property and utility management. It's marked not applicable.
Well, I think it is applicable because you need to know who's responsible for the upgrade, maintenance, and future replacement of any and all of that.
And I appreciate that, and I would cast it slightly differently. There will be an amendment to the current HOA declaration that subjects this, like the roads, for example, to that plan. Again, this is an AG approval process, but long story short is it is applicable, but it's not creating things from whole scratch. It's adding this portion of the subdivision to the
So
other.
they're gonna, once it's complete, you're gonna turn it over to the other existing HOA.
That's my understanding. We could do a separate HOA, but I think the plan is stay with the current one. And it's the way it works is we essentially amend the current declaration to add this subdivision to it, just like we've done for the others, just to be clear. So we will be.
That's a change from what was originally proposed. Yeah, because originally it was gonna be it was gonna be separate as the way it was proposed to us.
And to be clear, depending on how this all shakes out, there may be a separate HOA or HOA for certain aspects. So let me give you an example. There's an umbrella HOA for the development, but for example, there's a condo inside the association. So there's basically a sub-association that deals with the condo, but it's also governed by the umbrella or the master. There may be one of those here for certain things like, if there's a particular drainage or some shared improvements, but are only for a couple of lots. Until myself and my colleague who are drafting these documents kind of put our heads together, we're not sure exactly how we're going to tackle it. But long story short is the town will be aware who is responsible once we get to the end of this process. And I expect, again, a condition subsequent that makes sure that's the case based on what the AG approves. So
That was my question, to make sure that the town knows who's responsible for it. Yeah.
fair enough. Yes, I'm sorry. Gotcha.
Okay, good. Subdivision regulation compliance statement, C 5.02 B2. Required and provided. Space for board endorsement required and provided. Okay, does anyone have any questions or comments on that? Paul?
Yeah, I just have, after going through that last marathon we went through, I have the question about the stormwater and the percentage of lot coverage, whether drainage is included in this calculation here or not. Is there any comment to that from either the board or the applicant?
I mean, right now, we're not gonna accept the subdivision tonight. We're just accepting the application. We're taking a vote on the application. So we can
No,
still
I
address.
understand that, but I mean, I suppose that could be part of one of the application items, but I didn't know if that was, if we could consider that or not, I guess.
We can consider it. Can you elaborate a little bit, please?
Me?
Yeah. What would
Yeah,
you
I
like?
mean, and I don't have the application in front of me, so I'm.
It's okay.
I just didn't know if we could, under one of those items, consider whether or not the drainage and stormwater areas were included in part of the calculation of the lot sizes.
I guess I don't fully understand the question. But I would also ask, is this related to the completeness determination or, you know, because sounds like a technical question.
He's asked a question, so I'm just.
Yeah, so I guess I don't fully understand what the question related to lot sizing or related to is the impervious area on the lots included in the stormwater design?
No,
I
the
think I can
question
answer
is,
from the last application, because I think and you can correct me if I'm wrong, but there was a representation by an abutting property owner with the last application, that the special exception criteria that say that you must remove from your density calculation stormwater improvements. The question is whether that was done in the calculation of our lot sizes here.
Well, I don't believe we have any stormwater improvements. Trying to look on these lots. I would have to dig into that a little bit to answer the question, but I think
you take a look, yeah.
But I think this goes back to whether or not this is a minimum lot size question, which again, I think we can address through the process with Ray. You know, and the stormwater design in full disclosure is still moving because we are still in the process of addressing DES comments. So we don't have that finalized yet. So I don't know what the final stormwater configuration is going to look like to answer that question. But I guess the broad answer is, yeah, we can address the lot sizing as part of this without concern from our perspective.
Okay, so from the legal perspective, I think I may want some guidance. I mean, if every time we're going to come before the board for another 10 lots, 5 lots, 20 lot subdivision, we're going to get the same question again, which is, well, does the lot size apply or not? Our position, I think, I'd be clear, is the density has been determined already. They divided the total number of acreage by what was required, 15,000 square feet. And the point of the exercise was not to go for each and every application, say each particular lot meet the requirement, because there will be some lots that don't. For example, when they get around to doing the hotel condo type design, there's no way that lot is going to meet that criteria because that's not the way it's going to work. And that was the point, I think, of the master plan, was just some lots will be bigger, some lots will be smaller, etc. And I really would like guidance. If the board is at some point going to take the position that we have to address density each and every time, then I'd rather flash that out now and get Jason on the horn and get a decision. Because I don't want it to come back now and every year we're in here to have to say the same thing again and have somebody maybe reach a different conclusion one time versus the next. So I'm not saying it needs to be decided tonight, but I would raise that as a concern for me from the legal perspective, because it's hard for the engineers to know what they're doing if the board isn't clear on what they're going to require, or if they're going to depart from, in my view, depart from the master plan, then I would say, please let me get Jason involved so we can have you guys consult with him, frankly. So anyway, I don't know if you're want to talk about that now. I know Paul has raised this. I appreciate him raising it. I understand he's concerned about it.
I think the mo-
I mean, considering this is a plan phase development, I think, you know, you're probably right. I think the planning board should have a discussion with Jason about how it's gonna proceed in the future. I think clearing the air is probably a good thing to do. And I think that, you know, that there's been a lot of different developers over there through the time, and that the master plan has changed. And, you know, as things evolve, there's gonna be more changes. So yeah, I guess it is important. I mean, it's no different than when it was first approved, we were supposed to have smaller house lots on it, and they had bigger house lots. From my understanding, most of the designs were there not only based on the lot sizes and the amount of space that you had, but it was also based on how much green space was available. It was more than that. It was based on what the total number of gallons were going to be available when the thing was built out per bedrooms. So there's been some things that have changed over the time, and it probably would be a good thing to flush some of that out.
And to provide some guidance, here's how I compartmentalize it in my own way of conceptualizing how this works. When it comes to lot size, I think the master plan basically says we're not going to look at lot size in each and every lot to determine whether or not the lot size is appropriate, because we've done that as a whole. However, you are correct. I think we still have to abide by impervious surface requirements, setback requirements, etc. And my understanding is, you can correct me if I'm wrong, is that these lots are all designed in a way that regardless of their size, they will meet those other requirements. In other words, we're not exceeding the impervious surface portion of the lot. We're not exceeding a setback. And then finally, on the water issue, I view that as a completely separate issue in this way, that the units counts were in fact factored into the water usage, and that there will have to be a true up as this project gets near the end. If they come in and, you know, to do a large hotel condo type thing, I think there'll have to be essentially a refresher on the water to either show you that we are not exceeding what we said we were going to, or have undertake a different analysis so that we kind of clear the air, say, okay, here's where we are and here's what you need. But again, for this purpose, I don't know the numbers off the top of my head, but I can say that, you know, we are nowhere anywhere close to being at any kind of capacity in any way, shape, or form. I mean, I guess we're less than a third or something. But I hear you, and I think as this progresses, I think it would be helpful for you to get guidance from Jason about, you know, density. When you say density, lot size versus impervious surface versus water usage. I hope that's helpful. That's how I look at it.
Okay. I don't think we need Joe.
Nothing that's smaller than 50,000 square foot. Whether or not we have to deal with it, that came forward. I'm figured it out and get them. And all we're gonna be minimum lot size, even though the overall concept is coming a lot. Let's get one lot here and follow.
Mike, I'm not disagreeing with you, but what was the concept with the hotel? Like, you can't have 15,000 square.
Oh,
okay, all right.
If you use that criteria, Joe, they can put more than 1,018 units on the site. So.
Yeah, I mean,
every hotel room theoretically is allocated 15,000 square feet.
Yeah, I mean, so you're right. I mean, technically, we could build whatever the number was, can't remember, up to my 2014 or 2018. We could build 1,018 single-family homes and meet the density requirement under the ordinance. And the idea, I hear you, but again, that wasn't the idea. The idea was you're going to have, for example, the hotel, which takes up, you know, it's a higher rise, Therefore, it's going to take up less density. Therefore, you got, more space to round. I hope you understand the concept. We're not trying to skirt it. We're just saying that as I see it, every time we come in this.
Go back a little.
That's right. I would like some clarity. I think I'm interpreting it correctly. If Jason disagrees, and looking at these, I'm happy to talk with him and we can figure it out. But we just need some clarity so that when these guys are doing this every time, we're not wondering.
The first thing, give you the order. Just like the 50,000 square foot from the building. Yeah.
Appreciate the comment. Thank you.
You go down, way down front, 50 feet left. What's the 20 feet apart? Put your downtown bar. That's not as serious should be to me. To me, is you're creating another city within the current people. If you look here and they want to bring into the area. Now, if you look at now the other cities they play with, it looks like downtown Boston now.
And I think the idea was a mixed use throughout the development. I mean, some is close, some is farther apart, and that there's a lot of open space in between when you. It's a.
You know, the road. Looks like they're on 20 feet apart, all the way down through.
I will just remind you that this was initially approved as a cluster, which the idea is to put a cluster where there's density and then lots of open space. There you go. How about that?
I think if you look at the plan, this plan that we're talking about, I believe all the lots are 15,000 square feet or greater. For this
Maybe a
plan.
move. So,
Yep,
I appreciate.
Yep.
All right,
So
that's
are
all.
we ready to vote on the completeness of the application? Sure. Right. Is there a motion to accept the application as complete? Second? I'll second that. Okay, all in favor?
Aye.
Anyone opposed?
No.
You voted no, Paul?
No, I voted aye. I'm just a little.
Okay.
behind.
A little bit of delay.
Yeah.
Yeah.
By the time I say opposed, I see your hand going up, so I know what's going on.
It usually does.
All right, so let's open up some.
Oh, you're
Is there-
laughing.
Is there any public comment? Make a motion to open public comment. So okay. Second?
I'll second.
All right. Joe, second. All in favor? Aye.
Aye.
Is there anyone in the public would like to speak at this time?
I'll speak at once.
All right, let's close the public comment for this meeting. Second. All in favor?
Aye.
All right, so when will you be ready to come back?
So I believe we'll be ready to come back next meeting.
May 8th.
Yep, for at least another discussion on the open space. We'll let you know if we need to delay on that, but right now we'd like to come back. And continue this. I don't know where Ray will be in his review by that point in time.
Okay.
We are ready to respond to anything he comes back with us. We're just kind of waiting on him to give us a complete response on our plans. So that's kind of where it's mostly in his court at this point. Again, we'll continue to work on our state response for the wetlands. That's kind of where we're at. So I think we will be ready to come back with a lot of this information next meeting. We'll kind of group up internally about what, the things like the bonding and the HOA agreement, the HOA documents and all that stuff and what we're going to provide for that.
Just so you know, and I think I mentioned this at the beginning, I provided to Jason a template for each of the easements and for a description that what would be covered by declaration and AG approval. And he was fine with all that conceptually. And frankly, I think we've done everything we can on that side of things until an approval is granted, at which point conditions subsequent as we finalize those. But it really isn't that complicated. It's just identifying where they are on the plan and saying, is this a drainage or is this a driveway or is this the HOA or is it lot A versus B? And that was not a big deal. So, there's a lot of them, but it's routine. It's not a problem. I was just curious when it comes to review. I'm sort of outside this world of engineering review. Does the board have a policy or something with respect to consulting review and like when they're supposed to get?
So that's something we're gonna be discussing at a subsequent meeting.
Okay.
Yeah, we're working to get clarification because we have tweaked the policy in the last year, so it's not quite as clear as we'd like it to be.
Well, I get it. I mean, I think it'd be helpful, kind of speaking for South Peak, but really for anybody here, that you know, if a plan gets to the consulting engineer, you know, there are circumstances, you know, an illness or something like that, but generally, you know, what's the expected turnaround time? And, you know, or maybe you can base it on, it's got to be back to them, you know, within a week before the next meeting, or however you set the time frame. Because what I've seen so far is, you know, comments come in at 5:30 the day before, and there's just no way.
Yeah,
And you guys are in the same position. You're wasting your time in a meeting because.
right, board members have brought that concern up as well.
Okay.
Well,
Yeah.
and what for us, it's really about the completeness of the comment. So, you know, again, understood that Ray's time limited, but you know, we've got 2 letters that we've responded to, but we still do not have a complete package of like, okay, if you address all this, I'm good with it. We don't have that at this point. We don't know what else is outstanding. And it seems like we're always playing catch up on that. Like every time we respond to a letter, we get another letter that has different comments on it. And it's like, well, wait a minute. We need one letter that these are all my comments. If you address all these comments, we're good. And so that's the challenge that we face. And that's why, you know, like, for example, the Fireside one, we had 6 or 7 comment letters because like we'd respond to something and in the process of us responding, we would get another letter that was following up after the fact. So it's like, it just never ended. So.
But I often see in other towns, it's like a funnel. Like usually there's one big review and they're the technical comments. Then the applicant responds. And then maybe there'll be another review, but now instead of this wide, you're down to these issues.
Yes,
And
exactly.
then they respond and address those. And they're like, okay, with your response, I still got, you know, these 3 or 4. That's kind of the way it works. Here, what I'm seeing is here. And then we come back and like, oh, here, but we're just talking about these other things that were on the plan initially that I didn't tell you about the first time. Now can you address them also? Then you get another one that's this big, but now it's additional things that were on the initial plans that I finally got around to reviewing. And that it's very frustrating thing for the.
No, that's exactly it. That's exactly it. Is, you know, as long as it's within the bounds, you get one complete review, and then you're going to have a few back and forths. That's expected. You might have 3 or 4 volleys back and forth, but as Derek's point, it should be the funnel where you've got a complete review, address all this. Okay, we got to refine this a little more. Okay, we got to refine this a little more, and then you're there. But again, if you're at the 3rd step, and then oh, by the way, we got this other thing that we haven't even talked about yet. We need that addressed too. It's like, oh, now we're back to square one again because sometimes it impacts everything else. So
We appreciate your comments.
Yes, I did not realize that was the slowdown. I thought it was, you know, you changed something, but he didn't like the way you changed it, so you.
No, not.
You're talking about some whole new issue brought in after like 1 or 2.
Like, I'll give you an example. For Fireside, we did, I think we were very far along, review letter 5 or 6 or something like that. And then we got a comment on propane tanks. Why aren't propane tanks on the plan? Well, we wish we had seen that on comment letter number 1, 2, 3, 4, you know, like that was a new thing that added that was like, oh, by the way, I missed this during my review, you know, and it's like understood, but it for us, it's like, man, you know, we're just trying to refine this to the point where everybody's happy with it. Now, granted, we do change some things, and things, that one in particular, some things changed, and Ray had to go back for, so in his defense, absolutely that did happen, what you're describing. But it's again back to what we're talking about today. We have 2 comment letters, which Ray was rushing to get us stuff to look at, which understood, but we still don't have like, okay, here's our complete suite of comments. Here's what you need to address. So again, it just, without having that, it prolongs the review because things are moving. So.
In other words, maybe something might be better if you don't give me the comments right now. Appropriate amount of one blanket that it comes down.
Yeah, I mean,
You and everybody else.
exactly. So if you look at the state.
They're going to teach me.
Yeah, exactly. This, like, if you consider the state permit review process, right? So the state permit review process, the rules say that they're supposed to give you a single and complete response to your application. Like, give us all this stuff and we'll give you your permit. So then we are supposed to provide a single and complete response to that. And then there's always a couple of little volleys back and forth. But again, to Derek's really good example, it's that funnel where you limit and you refine and you refine and you refine until everybody gets to the point where you got all the issues addressed. And that's what we really need to get to. What's that? No, you don't want to sit. No, you don't want to sit. It just makes it more efficient for everybody. And it's streamlined. So that's our,
We
that's.
appreciate
That's
that.
good comment. It'll save you guys time too, I think. I really do.
So we need a motion to continue this hearing to May 8th.
Second.
Second, Joe made the motion, Rudy second, all in favor? Aye.
Aye.
See
Okay,
you in 2 weeks.
see you in 2 weeks. Good.
Right. See other business, we got a letter from Danielle Black. She's requesting a leave of absence for a 3-month period.
I didn't see that. She wants to be gone for how long?
3 months, April 19th, 2024. Town of Lincoln, 148 Main Street, Lincoln, New Hampshire, 03251. Dear Mrs. Park and members of the planning board, I'd like to request a leave of absence for a 3-month period as I have personal matters and responsibilities that need my attention. If I can attend a meeting within that period, I will notify the planning board and Carol so that we can prepare the proper number of packets. That meeting, if you have any questions, please feel free to contact me on the number above. Thank you, Danielle Black.
That's not the one, that's not the one letter I got in my packet. She was resigning.
Well, I think initially she was gonna resign and then she changed her mind.
Well,
She didn't feel it was,
her letter stated she was gonna be too busy to make the meetings. I mean, I think we need, I listen to these people talking tonight, and I think we need a more consistent board too. I mean, it's not if Danielle wants to be on the board, she can be on, in my opinion, she can be on the board all she wants, so long as she asks every time to be excused. That's the law. But a leave of absence is not within the law. So I mean, to me, we need a full-term person sitting in here. And if Danielle does not want to be that, why doesn't she just be an alternate? We'll move Joe back up to a full-time member because he comes to almost all the meetings, and then we'll have more of a quorum available. That would be my comment. I'm not trying to kick her off. I'm just saying something that would fit her better would be an alternate position, and that way there we would have somebody who's been on the board be a full-time member, and better chances to have a quorum and so forth. So
Let's say my side, but it's me and somebody else, need somebody who can have some kind of board that has some kind of
I can't hear you, Joe.
continuity.
The board had to, no matter who's on sitting in a place, maybe some kind of continuity so you can go from one meeting to the next, and not try to catch up.
Right. I mean, and that's all I'm saying. I'm not trying to beat her to death there. I'm just trying to say it would be more advantageous for her to step down and be an alternate again. She come back and be a full-blown member if she sees she's got time available next March. But it'll give her a chance to reassess, and she can still come to the board meetings when she wants. I mean, a leave of absence is nothing within the law to do that. She can stay on as a full member. All she got to do is call Jimmy every time and say, "Hey, I need to be excused." But I don't think that lends to as Joe just said, the continuity of the board. So, and it's not like we'd be putting a new member back on either. But for me, I gotta tell you, I'm not in favor of a 3-month absence. I can tell you that.
Would you guys rather I reach out to her and see what her intentions are?
Well, I think I think you ought to reach out to her and tell her that, I mean, take an alternate position, then you can get your work or whatever your life or whatever else your other commitments in order. You can show up when you want to show up, and then for the sake of the board, we could have Joe, who's now an alternate, be a full-blown member, and then we can have that continuity. I mean, I would think she would happily go along with that, but I mean, I don't know if anybody's approached her with that.
We can't force her to be an alternate. She has to do it on her own.
Jim, I understand that, but you
Okay.
just asked if you should reach out and contact her, and you're the chair, so why don't you reach out and contact her and say, hey, and just.
Well, I don't make moves without consulting with the rest of you.
Right, I think it's good that you brought this up, and I think that's good that people are contributing. I would, I guess, present the options that, as Paul said, you can't just, I mean, I don't know if it's not legal, but it's not typical.
We don't have any procedures in place if someone doesn't show up. There's no, right, there's nothing, you missed 3 meetings, you're off.
But I would say that it either
There is that.
would need to be an excused absence and each time call you and let you know if you can or cannot. And then or presented with the option of being an alternate. Let her
Okay,
weigh, I know there's some things going on and maybe she just needs some time to see.
Yeah.
What that time commitment is gonna be.
And it doesn't mean that she won't get the information because she'll still be an alternate. So if she
Yeah.
wants to participate, she can be back and forth depending on what,
I mean, Carol made her a packet, she can still be up to speed what's going on.
Right, but in the meantime, we can have the continuity of having more people on the board.
Okay. All right, I'll give her a call over the next couple of days. See what she wants to do. All right, so we had one other letter, Mike, can't think of his name. What's this gentleman's name to put in a letter? We had one in the packet last time. Yeah. Mhm.
I think I have it here. Mike Hiroki, okay.
Is this something we want to vote on tonight, or you want to wait till next meeting?
Hey, can I make another comment about these speakers? As the night goes on, I don't know if it's me, but like Joe, you're really hard to hear. OJ, you're hard. Jimmy, I can hear you good. Steve
It's
doesn't.
funny, we're furthest away from the microphone.
Speaker's probably too far away from us.
Yeah, you gotta have the microphone.
No, he said he would.
I'm just making a comment so you get somebody else's who's sitting and listening.
I'll move on.
Do a sound check.
Do you want me to read the letter?
Yeah. What the heck?
This is from Michael Iaraki, 41 Goodwood Road. I'm seeking to become an alternate planning board member. My interest is to have a deeper understanding of how the town works and be a part of Lincoln's future. My family and I have been coming to New Hampshire since 1971. We've been enjoying the White Mountain region since then. In the mid-70s, we purchased property where is now 41 Goodwood Road. Since 2016, I moved from Rhode Island and became a permanent resident of Lincoln. In 53 years of being here, I have seen so much change and growth. I own and operate a small construction remodeling company, MI Tradeworks LLC. I have invested my livelihood in planning to live out my life here. I would like to be a proactive member of the community in Lincoln's future. Best regards, Michael Iaraki.
Sid lives up beside me. Sid lives in Chili's old house.
Okay. I
So,
would
go ahead.
suggest we invite him to come to a meeting so we can meet him. Talk to him about what the planning board involves and then take it from there.
I would agree.
I agree. Okay, so I'll have,
Notify him.
we'll reach out to him. All right, any public participation? Amy?
On your. Right, was that for each application? Was it, they can just add?
Yeah, they received their final approval subject to the conditions we noted. Well, they have to say, they have to satisfy the conditions of technical memo number 3.
And I just something that work for like either side happy, but it would work. As a native to this town and a taxpayer to this. This is my personal opinion, and you guys can bash me however you want.
You need to set the microphone.
Oh, Paul. So anyways, this is my opinion as a native of this town, as a taxpayer of this town. I think the town people that voted this board in has gotten shit on big time. I really do. It saddens me to see the board go by the word of these people who are here wanting to develop. instead of talking to your attorneys? To get all these answers from the attorneys before that meeting was approved. And we saw one person on this board say they were against it at this time. Not totally, but just at this time. And the fact that the developers weren't willing to consider, knowing darn well they were going to make profit back, or at least their money back. They're going to make profit back, plain and simple, by cutting it in half. I'm really disgusted at the representation I see of the staff that was voted in. I don't have anything personal against any of you. You're entitled to your opinion. But as a taxpayer, I am insulted to think, considering Attorney Dennis, I believe his name is, that the town pays for, has said 2 meetings ago that the developers could, if they so choose, they could retaliate. I'm at a loss of words right now. If this board went against them, they could fight it in court. And he also went on to say that the public could also keep this in litigation in court. Yep. To me, that was writing in between the lines. And it wasn't listened to.
Gary,
Just my opinion.
also, the decision we made, either back to appeal in 20 days, if we,
30 days.
30 days, appeal another hearing.
Yeah, well, you know what?
So you know,
I know what I can do, but I also know there's abutters that are going to be affected by it a lot more than me. I am just
I think
really,
we've appreciated their concerns and made a lot of changes to the plan.
and I've noted that at the meetings.
Yeah.
I have noted that at the meetings.
You know, I mean, we have to work with what the voters have voted in. We can't just say, oh, geez, we'll split the difference.
I
And I hope
understand
you
that,
understand that. We're
but
not,
I did not see you guys even really try hard to see if you could talk these developers into backing down a little bit. I did not see that. I know from what they originally started, they worked with all kinds of things, the wetlands, the roadways, all that stuff, but my opinion is the townspeople got screwed tonight. The ones that voted you guys in, there's only one here that stood up and said, I want to see what the attorneys have to say first. I want to have things done before I make a decision. Another meeting, but rush right through. So that's my opinion.
Well,
You guys do what you want with it.
in all fairness, we beat them up for weeks.
You're listening to it. But on one hand, we got people complaining about how these buildings are gonna go in and raise our taxes because they're gonna be a lot of money. We don't want that with the campus road land. And then I just hear Joe say something about sizing on South Mountain here. But it's okay, right in the center of town, in a quiet residential area, for this development to disturb every single person up on that property, that area. It's okay. That's sad. That is damn sad. Money talks. Town people don't matter in this town, and I am disgusted. And I, for one, will not sell out for anybody. So that's my opinion. You guys have a good night.
Thank you.
does anyone have anything else?
I'll make a motion to adjourn.
Is there a second? All in favor?
Aye.
Everything that goes on in this room, is it supposed to be recorded, every single thing as we do?
It's on YouTube,
Everything, right?
everything.
Let me hear it here, because
Night, Paul.